International law. Frequently asked questions on international law. Q1. Define international law. Give at least 3 definitions of international law. Critically analyze the definition given by Oppenheim. Ans. Definition. The words international law were used for the first time by Jeremy Bentham in 1780. Since then these words have been used to denote the body of rules and principles which regulate the relations among the members of international community. The term members of international community now denotes states, international organizations, individuals, and certain non-state entities. Oppenheim's definition. Professor L. Oppenheim has defined international law in the following words: the law of nations, or international law, is the name for the body of customary and conventional rules which are considered legally binding by civilized states in their intercourse with each other. Criticism. Oppenheim's definition, which was considered appropriate at one time, is now subjected to severe criticisms. This definition can be subjected to the following criticisms. 1. It is now generally recognized that not only states but international organizations have also certain rights and duties under international law. This view has been finally affirmed by the International Court of Justice in its advisory opinion on reparation for injuries suffered in the service of the UN, 1949. 2. It is also recognized that to some extent individuals have some rights and duties under international law. 3. It is also recognized that international law consists not only of customary and conventional rules but also of general principles of law recognized by the civilized states. This has now been expressly recognized by Article 38 of the Statutes of the International Court of Justice. 4. The use of the term civilized states has also been criticized. A few decades ago, Western states regarded only the Christian states as civilized states. For being considered civilized, neither long history nor culture was the criterion. That is why, in later editions of Oppenheim's book, the word civilized was deleted. New definition of international law. In latest edition of Oppenheim's book, the editors of the 9th edition of Oppenheim's book, 1992, Sir Robert Jennings and Sir Arthur Watts, have revised Oppenheim's definition of international law in the following words. International law is the body of rules which are legally binding on states in their intercourse with each other. These rules are primarily those which govern the relation of states, but states are not the only subject of international law. International organizations, and to some extent, also individuals, may be subjects of rights conferred and duties imposed by international law. Thus the above concept and definition of international law given the 9th edition of Oppenheim's international law is much better than the earlier definition and to a great extent similar to that given by Stark and Fenwick. But it is still deficient in one respect. It is silent about the general principles. 2. Some other definitions of international law similar to that of Oppenheim. Westran Central Gold Mining Co. Limited v. King, 1905, to KB 391. In this case the court observed, international law may be defined as the form of the rules accepted by civilized states as determining their conduct towards each other and towards each other's subject. S.S. Lotus Case, 1927, PCIJ Series A, number 101. In S.S. Lotus Case, international law was defined in the following words: international law governs relations between independent states. The rules of law binding upon states, therefore, emanate from their own free will as expressed in conventions, or by usages generally accepted as expressing principles of law and established in order to regulate the relations between these coexisting independent communities or with a view to the achievement of common aims. Restriction upon the independence of states cannot therefore be presumed. Gray defines international law in the following words: international law or the law of nations is the name of body of rules which according to the usual definitions regulate the conduct of the states in their intercourse with one another. Hall. According to Hall, international law consists of conduct which modern civilized states regard as being binding on them in their relations with one another with a force comparable in nature and degree to that binding the conscientious person to obey the laws of his country, and which they also regard as being enforceable by appropriate means in case of infringement. Kelson. According to Kelson, international law or the law of nations is the name of a body of rules which according to the usual definition regulate the conduct of the states in their intercourse with one another. Criticism. The above definitions can be criticized in the same way as Oppenheim's definition has been criticized above. Q2. Trace the contribution of the Jews, Greeks and Romans in the development of international law. Ans. Jews. The Jews were in favor of foreigners. The Jews had the same laws for foreigners residing on Jewish territory as for themselves. A reading of Bible, however, illustrates that on account of their monotheism the Jews did not recognize other nations who professed faith in polytheism as their equals. They carried ruthless battles, enroving to the winds all canons of warfare. Jews were having international relations only with their friendly nations. They faithfully observed treaties and considered ambassadors as sacrosanct. They gave full protection to foreigners. Greeks. The Greeks were more civilized than their neighbors whom they regarded as barbarians. Their notion of superiority prevented them from developing neutral relations with their neighboring nations. Before Macedonian conquest, the Greeks lived in numerous small city-states which were independent of one another. The inhabitants of the states belonged to the same race, blood and religion. This close affinity, in course of time united these independent fragments into a community of states which observed certain rules inter se in time of war and peace, their dispute. They frequently resorted to arbitration for settlement of treated heralds and priests who carried the holy fire as inviolable, commenced no war without a previous declaration, gave burial to warriors dying the battlefield, changed prisoners of war, regarded the temple of the god Apollo as permanently inviolable, and gave special privileges to ambassadors who were ceremoniously received and their persons treated as inviolable. Oppenheim observes that the Greeks left to history the examples that independent sovereign states can live in a community which provides a law for the international relations of the member states, provided that there exist some common interests and aims which bind these states together. It has, however, not to be forgotten that the Greeks never made the same distinction between law, religion and morality which the modern world makes. But the fact remains that the Greeks set an example to the future that independent states can live in a community in which their international relations are governed by certain rules and customs based on the common consent of the members of that community. Romans. The Romans had an advanced notion of international law. They had a set of 20 priests, termed fetials, who managed relations with foreign states by the laws called jus fetials or jus sacrae. The Romans had one set of laws which were applicable exclusively to themselves, viz. Jus civil, the law applicable to Romans, and another set for foreigners, jus gentium, the law which they had in common with other nations. The jus gentium was later on strengthened by the development of jus natural, which was the law that was constituted by right reason, common to nature and to man. It was ultimately this law or jus fetials that governed the relation of Romans with foreign countries in times of peace and war, also when they entered into treaties of friendship with them. There were three kinds of such treaties, viz. Treaties of friendship, amicitia, of hospitality, hospitum, or of alliance, foedus. Roman law recognized four just reasons for war, viz. A. Violation of the Roman dominions, B. Violation of ambassadorial privileges, C. Violation of treaties, and D. Support given during war to an opponent by a hitherto friendly state. War could be ended according to Romans, I. Through a treaty of peace, 2. By surrender, deditio, or 3. Through conquest of the enemy's country, occupation. Treaties as said above were divided into three kinds. I. Treaty of friendship. 2. Treaty of alliance. 3. Treaty of hospitality. The Romans had great respect for treaties which could be terminated by notice. Q3. Explain the viewpoints of naturalists, the positivists, and the Grotians on international law. Ans. The 17th and 18th centuries gave birth to three different schools of writers on the law of nations, viz. The Naturalists, the Positivists, and the Grotians. 1. Naturalists. The Naturalists denied that there was any positive law of nations based on custom or treaties, but maintained that it was only a part of the law of nature. Samuel Pufendorf, 1632–1694, led this school. He maintained that states were bound to regulate their conduct towards one another by the law of nature, as they had no common superior. He agreed with Hobbes, de Civ. that natural law is divisible into natural law of individuals and of states, and that the latter is the law of nations. Pufender further observed that outside the natural law of nations there is no positive law of nations having the force of real law. The German philosopher Christian Thomasius, 1665 to 1728, was a great follower of Pufender. So were the English philosophers Francis Hudson and Thomas Rutherford, the French philosopher Jean Barbeyrac, 1674 to 1744, and the Genevan philosopher Jacques Burlamaqui. 2. Positivists. The Positivists differed fundamentally from the Naturalists and ascribed the growth of international law to custom and international treaties. They do not consider natural law as of any importance, but regard customary law based on treaties and customs to be positive international law and of highest importance. They gained importance in the 18th century. The Dutch jurist Binkenshoek, 1673 to 1743, the German writer John Jacob Moser, 1701 to 1785, and George Frederick B. Martens, 1756 to 1821, were the leading exponents of this school. Binkenshoek observed that the law of nations was based on the common consent of nations, expressing itself either in international custom or international treaties. This school represents the modern view of international law. 3. Grotians. The Grotians occupied a position midway between the Naturalists and Positivists. They maintained the distinction between natural and voluntary law of nations as propounded by Grotians and kept both as the basis of the law, but unlike Grotians they considered the positive or voluntary law of nations as important as the natural law of nations. They gained enormous influence during the 17th and 18th centuries. Q4. Whether an international law is a law in the true sense of the term or not? Comment. Ans. Whether international law is law in the true sense of the term or not. The controversy whether international law is true law or not depends upon the definition of the word law. If we subscribe to the view of Hobbes, Austin and Pufender, that law is command of sovereign enforced by superior political authority, then international law cannot be included in the category of law. On the other hand, if we subscribe to the view that the term law cannot be limited to the rules enacted by the superior political authority, then international law can be included in the category of law. According to Austin, law is given by a determinate superior political authority to political inferiors and is backed by a coercive enforcement agency. Thus, according to Austin, sanction occupies an important place in the enforcement of law. Hobbes also subscribes to this view. In the view of Hobbes, man is by nature nasty, brutish and violent, and fear or sanction which is inherent in law is necessary to maintain order in society. The definition of law by Austin is not correct. In the words of Professor Oppenheim, this definition is not correct. It does not cover that part of municipal law which is termed as unwritten or customary law. There is, in fact, no community and no state in the world which exist with written law only. In his view, law is a body of rules of human conduct within a community which by consent of this community shall be enforced by external power. Brierley and Professor Hart have also criticized the Austinian definition of law. According to Oppenheim, the existence of law presupposes the existence of three prerequisites: I, a community; 2, a body of rules; and 3, common consent of the community that if necessary these rules shall be enforced by an external power. The three requirements of this definition, I. Oppenheim's definition of law, are satisfied by international law to a greater or lesser extent. Conclusions. On the basis of the above arguments, it may be concluded that international law is in fact law. International law operates entirely in different setting. It operates in a decentralized system. According to Strake, international law is a weak law because existing international legislative machinery operating mainly through law-making conventions is not comparable in efficiency to state legislative machinery. International law can be said to be weak only when it is compared with municipal law. Much of the controversy relating to international law is due to the fallacy that the system of municipal law is an ideal one and all legal systems, and for that matter international law also must conform to that ideal. Municipal law operates in a centralized system whereas international law operates in a decentralized system. The comparison is therefore not a happy one. International law must be understood in its own setting and the system in which it operates. It is as strong and as effective as it can be under the system in which it operates. Q5. Is international law a mere positive morality? Comment. Ans. Various jurists have given their views on whether is international law a mere positive morality. A rule of morality applies to conscience and is, therefore, not binding. On the other hand, a rule of law is binding and can be enforced by external power. Most of the jurists agree that international law has binding nature, whereas the rule of morality is simply a standard of right behavior based on the personal judgment. As pointed out by Edward Collins, although attitudes about morality, when widely shared, influence the development of international law, there is no recognized legal obligation to obey the norms of morality until they are accepted by authoritative decision makers or international law. Frederick Pollock has rightly observed, if international law were only a kind of morality, the framers of state papers concerning foreign policy would throw all their weight on moral arguments. But as a matter of fact, this is not what they do. They appeal not to the general feeling of moral righteousness, but to precedents, to treaties and to opinion of specialists. Professor Hart also subscribes to this view. He adds, the rules of international law, like those of municipal law, are often morally quite indifferent. A rule may exist because it is convenient or necessary to have some clear fixed rule about the subjects with which it is concerned, but not because any moral importance is attached to the particular rule. Q6. Whether international law is the vanishing point of jurisprudence? Comment. Ans. According to Holland, international law is the vanishing point of jurisprudence. In this view, international law is followed by courtesy and, therefore, it cannot be kept in the category of law. Austin also subscribes to this view. The view of Holland does not seem to be correct. In the first place, sanction is not most essential element of law. Even if it is regarded as an essential element, it will be proper to say that international law has no sanctions at all. War reprisals, retortion, Pacific blockade, etc., were regarded as sanctions under the traditional international law, i.e., before the establishment of the United Nations. The Charter of the United Nations also contains a provision wherein the Security Council may recommend or decide upon the measures to be taken to implement the decision of the International Court of Justice. In the view of Holland, there is no judge or arbitrator to decide international disputes. This statement cannot be accepted because the International Court of Justice is the judicial organ of the United Nations and its decisions are binding upon the parties to a dispute. It is true the International Court of Justice lacks compulsory jurisdiction in the real sense of the term. Its decision cannot be applied to future cases as precedents, and, above all, the binding force of its decisions is very limited. Under Chapter 7 of the UN Charter, the Security Court possesses wide powers to declare sanctions against the states who are guilty of violation of the provisions of the UN Charter relating to international peace and security. UN action in the Gulf War, 1991, is a glaring example of this. Reference may also be made to the UN sanctions against Libya in Lockerbie case I bombing of Pan American flight airliner in 1988 over Lockerbie, Scotland, killing 270 persons. Earlier, the UN had taken enforcement action under Chapter 7 of the Charter in several cases such as in 1948 against North Korea and in 1961 in Congo. On the basis of above discussion, it may be concluded that international law is, in fact, law, and it is wrong to say that it is the vanishing point of jurisprudence. Q7. Distinguish public international law with private international law. Ans. Distinction between public international law and private international law. The main points of difference between public and private international law are the following. I. Public international law for its major part deals with states and to a lesser extent with the individuals. Private international law deals with the individuals. 2. Public international law is a part of municipal law, but so it is not always the case with public international law. 3. Public international law, at least the rules having general application, is same for all the states, whereas private international law may be different in different states. 4. Private international law determines as to which law will apply in a case having a foreign element. There is no such problem in the field of public international law. Private international law also determines the court which will have jurisdiction to decide the issue in question. In this respect also it differs from public international law. 6. According to Robert Phillimore, rights arising out of public international law are absolute, and their breach constitutes a casus belli, i.e. whatever involves or justifies war. This view does not seem to be correct in the presence of the provisions of Kellogg-Briand Pact and the UN Charter, which have outlawed war. But private international law does not at all confer absolute rights. 7. International law comprises mainly of the rules recognized by states in their relations with each other, and mostly arises out of international customs and treaties. On the other hand, rules of private international law are framed by the legislature of a state and recognized and developed by state courts. Q8. What are the weaknesses of international law? What do you think are the suggestions for the improvement of international law? Ans. Weaknesses of the international law. Following are the weaknesses of the international law. 1. It lacks effective authority to enforce its rules. 2. It lacks effective legislative machinery. 3. The International Court of Justice has no compulsory jurisdiction in the true sense of the terms. 4. The sanctions behind international law are very weak. 5. It cannot intervene in the matters which are within the domestic jurisdiction of states. 6. Many rules of international law are uncertain and vague. 7. International law has failed to maintain order and peace in the world. Suggestions for improving international law. 1. The International Court of Justice should be given compulsory jurisdiction in the true sense of the term. 2. An international criminal court should be established to decide cases of international crimes. 3. International law should be properly codified and scientifically revised from time to time. 4. The machinery to enforce the decisions of the World Court should be strengthened. 5. The powers and scope of the activities of the International Law Commission should be expanded. 6. The doctrine of judicial precedence should be applied in the field of international law. 7. In order to strengthen the legislative machinery of international law, more lawmaking treaties and conventions should be made, and there should be a provision for their revision from time to time. 8. The legislative activities of the General Assembly should be further enlarged. 9. Such activities of the UN should be encouraged as may develop the feelings of international community in the true sense of the term. 10. The UN Charter should be amended as to authorize the UN to intervene in such matters with the domestic jurisdiction of state as are of international concern. Q9. What are the major sources of international law? Describe each source in detail. Ans. Sources. The first 5 sources find mention in Article 38 of the Statute of International Court of Justice. 1. International conventions. The term convention applies to any treaty, protocol or agreement, regardless of its title or form. According to Article 38 of the Statute of International Court of Justice, it is the first source of international law. In the modern period, international treaties are the most important sources of international law. As defined by Article 2 of Vienna Convention on the Law of Treaties, 1969, a treaty is an agreement whereby two or more states establish or seek to establish relationship between them governed by international law. 2. International customs. International customs used to be the most important source of international law in the past. In the modern period, their importance has lessened. Custom is a habit which has been repeated for a long time and has ultimately assumed the force of law. Usage is the earlier stage of the development of custom. By usages mean those habits which are often repeated by the states. Custom begins where usage ends. Usages may be inconsistent and opposed to each other, but so is not the case with custom. 3. General principles of law recognized by the civilized states. According to Article 38 of the Statute of International Court of Justice, the general principles of law recognized by the civilized nations are also one of the sources of international law. This is an important source of law through which international law adapts itself in accordance with the changing times and circumstances. Res judicata, estoppel, etc. are the examples of the general principles of law recognized by civilized states. The general principles of law are those principles which are recognized by most of the civilized states. When the court finds that a principle has received general recognition, the court may apply it as a principle of international law. Chaucer Factory, Indemnity Case, Pub. PCIJ, 1938, Series A, Number 17. In this case, the Permanent Court of International Justice applied the principle of res judicata, also held that one who violates a rule is liable to make reparation. E. Mavromatis Palestine Concessions Case, Pub. PCIJ, 1924, Series A, Number 2. In this case, the court applied the general principle of subrogation. G. Breslona Traction Case, Preliminary Objections, ICJ Rep. 1964, p. 6. In this case also the International Court of Justice applied the principle of estoppel. 4. Decisions of judicial and arbitral tribunals. The decisions of judicial and arbitral tribunals are also the sources of international law. But according to Article 38 of the International Court of Justice, they are subsidiary means for the determination of the rules of law. This source includes international as well as state decisions. As regards the decisions of the International Court of Justice, Article 59 of the Statute of International Court of Justice provides that they will have no binding force except between the parties and in respect of that particular case. Since the doctrine of precedent does not apply in field of international law, the international judicial decisions are not generally binding. They are regarded as subsidiary means for the determination of the rules of international law. The arbitral decisions have still less value because it is generally said that arbitrators work more as mediators rather than as judges. 5. Justice works. The opinions of jurists are also regarded as sources of international law. But they are also subsidiary means for the determination of the rules of international law. While deciding the case, if the court does not find any treaty or judicial decision or legislative act or any established custom, the court may take the help of opinion of jurists as subsidiary means for the determination of rules of international law. 6. Decisions or determinations of the organs of international institution. In the modern age, the decisions or determinations of organs of international institutions are also treated as sources of international law. International organizations have also become a subject of international law. The decisions and determinations of the organs of such institutions are also, therefore, regarded as the source of international law because they help in the development of customary rules or international law. The International Court of Justice has recognized it in a number of cases such as South West African cases, 1996, military and paramilitary activities in and against Nicaragua, 1986. Q10. What are the necessary ingredients of a custom? Discuss the importance of the custom as a source of law. Ans. Ingredients of elements of custom. Following are the main elements of an international custom. I. Evidence of a general practice accepted as law. Long duration is an essential element of a custom in municipal law. But this is not necessary for an international custom. Article 38 of the ICJ directs the World Court to apply international custom as evidence of a general practice accepted as law. 2. Uniformity and consistency. The custom should be uniform and consistent. 3. Generality of practice. Though universality of practice is not necessary, the practice should have been generally observed or repeated by numerous states. 4. Opinion juris necessitates. As pointed out by the International Court of Justice in North Sea Continental Shelf cases, I.C.J. Rep. 1969, p. 3, customary practice, even when it is general and consistent, is not customary law unless an opinion juris is present, that is to say, unless the practice is recognized as being required by international law. Importance of custom as a source of international law. There has been a marked decline in the importance of customs as a source of international law in the modern times. This is mainly due to the fact that the process of development of a new custom is very slow. However, in modern time also the development of new custom is possible, and at times customs have developed with accelerated speed. Principle relating to sovereignty over airspace and continental shelf are its glaring examples. But in view of the accelerated speed of the changes in international community, custom has become an inadequate means for bringing about the desired changes and development of international law. Thus, though the custom has been relegated to second place in importance, it still occupies an important position as a source of law. Q11. What are the main theories regarding the relationship between international law and municipal law? Ans. There are 5 theories regarding the relationship between international law and state law. 1. Monism. 2. Dualism. 3. Specific adoption theory. 4. Transformation theory, and 5. Delegation theory. The two main theories are monism and dualism, and other theories have been derived from these two theories. 1. Monism. According to this theory, law is a unified field of knowledge, no matter whether it applies on individuals, state or other entities. Thus, international law and state law are intimately connected with each other. They are the two branches of unified knowledge of law. According to monist belief, international obligation and municipal rules are phases of same phenomenon, the two deriving ultimately from one basic norm and belonging to the unitary order comprised by the conception of law. In the ultimate analysis of law, we find that individual is at the root of all laws. In the ultimate analysis, all laws are made for individuals. Wright, Kelson and Duggett, etc., are some of the prominent exponents of monism. Theoretically and logically, this appears to be the correct theory, and it is very difficult to disprove it. However, it may be noted that this theory is not based on the actual practice of state. 2. Dualism. According to this theory, international law and municipal law are two separate laws. Tribal and Angelotti are the chief exponents of this theory. According to Tribal, international law and state law are different because their subject and origin are different. In his view, individual is the subject of state law, whereas state is the subject of international law. Besides this, origin of the state law is the will of state, but origin of the international law is common will of the states. As regards origin of international law, the conception of state will is not correct. It is rather metaphorical. In fact, the state will is nothing but the will of the people who compose it. There are certain fundamental principles of international law which are binding upon the state even against their will. Whether monism or dualism is the correct theory. The above discussion shows that monism is a more correct theory, but it is submitted that no theory can be complete in itself, and it is not possible to include all the elements in it. The practice of state indicates that sometimes there is a primacy of international law, sometimes there is a primacy of the municipal law, sometimes there is mixture of different legal systems. For example, in the Greco-Bulgarian community's case, PCIJ, 1930, Series B, Number 17, the Permanent Court of International Justice held, it is a generally acceptable principle of international law that in relations between powers who are contracting parties to a treaty, the provisions of the municipal law cannot prevail over the treaty. On the other hand, when the municipal courts find that the conflict between the international law and municipal law is of such nature that cannot be avoided, they give primacy to the municipal law. In this connection, Mortensen v. Peters, 8, Sessions Cases, 5th Series, 93, 1906, and Sri Krishna Sharma v. The State of West Bengal, AIR 1954 calories. 598, deserves a special mention. 3. Specific adoption theory. This theory is based on the theory of positivists. According to this theory, international law can be enforced in the field of state law only after it has been specifically adopted by state law. This theory can also be subjected to criticism because there are several principles of international law which are applied in the field of municipal or the state law without specific adoption. However, this view is generally followed by state in respect of international treaties. It is argued that unless there is specific adoption of the international treaties such as Tokyo Convention Act, 1975 and Vienna Convention of Diplomatic Relations Act, 1972 enacted by Indian Parliament, or there is some sort of transformation, international treaties as such cannot be enforced in the municipal field. While considering the International Convention on Civil and Political Rights, the Supreme Court of India has held in Jolly George v. The Bank of Cochin, AIR 1980 SC 470 at pp. 474, per Krishna Iyer, J. The positive commitment of the state parties dignifies legislative action at home but does not automatically make the covenant enforceable part of the corpus juris of India. As regards specific adoption of international treaties by Indian Parliament, the Anti-Apartheid, United Nations Convention, Act, 1981, the Anti-Hijacking Act, 1982, the Suppression of Unlawful Acts Against the Safety of Civil Aviation Act, 1982 and the International Monetary Fund and Bank Amendment Act, 1982 deserve a special mention. It may, however, be noted here that there are many principles of international law, especially customary rules, which are applied in the field of municipal law without specific adoption. 4. Transformation theory. According to the exponents of this theory, the rules of international law to be applied in the field of municipal law must undergo transformation. This theory is also based on the theory of consent, which has been already criticized earlier. There are several lawmaking treats and principles of international law which become applicable in the field of municipal law without undergoing the process of transformation. The Headquarters Agreement between the United States of America and the United Nations is a glaring example of this. 5. Delegation theory. The critics of transformation theory have put forward a new theory called delegation theory. According to this theory, the constitutional rules of international law permit each state to determine as to how international treaties will become applicable in the field of state law. The constitution of each state contains provisions in this connection. Thus no transformation takes place. This theory is based on presumption and has been severely criticized. Q. 12. What do you mean by codification? What are the major factors which led to codification? Ans. Meaning and definition of the term codification. By the term codification, we ordinarily mean the process of reducing the whole body of law into code in the form of enacted law. It generally connotes a systematic arrangement of the rules of law which are already in existence. According to R.Y. Jennings, codification means any systematic statement of the whole or part of the law in written form, and that it does not necessarily imply a process which leaves the main substance of the law unchanged, even though this may be true of some cases. History of codification. The history of codification dates back to the 18th century when the idea of codification of international law was conceived by Bentham. Before him, an unsuccessful attempt was made by the French Convention to draw up a Declaration of the Rights of Nations in 1792. Declaration of Paris, 1856. The Declaration of Paris occupies a place of significance in the development of codification of international law. This declaration was signed by Britain, France, Austria, Russia, Turkey, Prussia and Sardinia after the end of the Crimean War in 1856. This declaration laid down the principles relating to a. Abolition of privateering, b. Non-capture of neutral goods except contraband of war, under enemy flags, c. Blockade to be binding must be effective, and d. Except contraband of war, enemy goods cannot be captured under neutral flag. Codification under the United Nations. Article 13, 1. Of the UN Charter lays down that the General Assembly shall initiate and make recommendations for the purpose of promoting international cooperation in the political field and encouraging the progressive development of international law and its codification. The UN General Assembly took the task of encouraging the progressive development of international law and its codification in all seriousness. On 11 December 1946, the General Assembly appointed a committee for the progressive development of international law and its codification. In 1947, the General Assembly decided to set up an International Law Commission. An International Law Commission was elected and it met on 11 April 1949. As provided under Article 1 of the Statute of the International Law Commission, the Commission shall have for its object the promotion of the progressive development of international law and its codification. Further, Article 24 provides that the Commission shall consider ways and means for making the evidence of customary international law more readily available, such as the collection and publication of documents concerning state practice and of the decisions of national and international courts on questions of international law, and shall make a report to the General Assembly on this matter. Work of the International Law Commission. The Commission began its work in 1949 and since then it has done commendable work in respect of the codification of international law. It decided to give priority to the following three topics: I. Law of treaties, 2. Arbitral procedure, and 3. Law relating to the high seas. In addition to this, the Commission has also worked on the various recent conventions and treaties. Geneva Conventions on the Law of Sea, 1958, Vienna Convention on Diplomatic Relations, 1961, 1965, Convention on Settlement of Investment Disputes between the State and Nationals of Other States, Vienna Convention on the Law of Treaties, 1969 are some of the landmarks in the field of codification and progressive development of international law. Besides these, UN Conventions on Biodiversity, 1992, UN Convention on Forestry, 1992, UN Convention on Climate Change, 1992, etc., deserve a special mention. Moreover, for the progressive development and codification of international trade law, a United Nations Commission has been established. Q13. What are the merits and demerits of codification? What do you think about the future of confidication? Ans. Merits and demerits of codification. Merits of codification. 1. One of the defects of international law is uncertainty. Codification not only makes rules clear and certain but also reconciles conflicting and divergent views. 2. Codification will be helpful in filling numerous gaps existing in international law and also by providing for rules where there is none. 3. Yet another merit of codification is that it will bring uniformity in the international legal system. 4. Codification will also go a long way to end or at least greatly minimize the disagreement and confusion that prevails on many important matters. 5. Codification will enhance the efficacy of international law by increasing its binding force. 6. The International Court of Justice and other tribunals will find it easier to apply and enforce codified international law. 7. It will be easier and convenient to amend the codified international law so as to keep it at pace with the tide of time. Demerits of codification. 1. Codification is detrimental for the natural growth and future development of international law. This defect can be remedied by regular and scientific international law. This defect can be remedied by regular and scientific revision of codes in order to incorporate changes in international conditions. 2. Yet another disadvantage of codification is that it makes the system of law too rigid and unadaptable to new situations. 3. Codification also makes the law too formal and conservative. This defect can be removed by progressive interpretation of international law. 4. New controversies arise due to codification. 5. It gives rise to controversies in interpretation because of the hair-splitting tendency of judges to interpret the law. 6. International law still being in its infancy, only a partial codification is possible. 7. Last but not the least disadvantage of codification is that customary rules still form the bulk of international law and many of them are not yet fully settled, covering the whole area of international rules. Conclusion and future of codification. A critical perusal of the advantages and disadvantages of codification will lead us to irresistible conclusion that the advantages outweigh the disadvantages. Codification will make the law certain, single, intelligible and, above all, easily accessible to all. Many of the disadvantages of codification may be removed by carefully planning and regular and scientific revision of the code to incorporate changes in international conditions. International law can flourish only if the states are ready to yield their interests in the larger interests of international security. As suggested by Sir Cecil Hurst, in every country some small body of men devoted to the study and advancement of international law should take this work of codification in hand, working if possible to a plan which would have been drawn up and agreed on by some central international scientific organization like the Institute of the International Law, and that this central organization would set up machinery for the joint study and coordination for the contribution emanating from all national groups. Its value to government would be that of providing a firm foundation for the modification by treaty of any of its provisions which were found to be unjust or to work badly under modern conditions and in consequence to require amendment. Q14. Define state. What are the essential elements of state? Briefly describe the functions of state. Ans. Definitions of state. State is the main subject of international law. According to Salmond, state is a community of people which has been established for some objectives such as internal order and external security. In the view of Oppenheim, the existence of state is possible only when the people of state have settled under the highest governmental authority and habitually follow its order. Ideal definition of term state is not possible. However, in the modern period it is finally settled as to what are the essential elements of a state. Essential elements of a state. According to Article 1 of Montevideo Convention, 1933, the state as a person of international law should possess for ingredients a permanent population, b. a defined territory, c. a government, and d. a capacity to enter into relations with other states. According to Oppenheim, population, a defined territory, government, and sovereignty are the essential elements of a state. Holland has added one more essential element, namely, to some extent, civilization, because of which the state becomes an international person. Functions of state. The modern period has witnessed revolutionary changes in regard to functions of a state. Previously, the concept of a police state prevailed. According to this concept, essential functions of a state were to maintain internal peace and order and to defend it from external aggression. It cannot be denied that even today these are the essential functions of a state, but in the present period the concept of state has undergone significant changes. Instead of the concept of police state, the present concept is that of welfare state. That is to say, for the benefit of the people, state has to perform many social, economic, educational and cultural functions. However, these functions may not be termed as essential functions. They are in fact subsidiary functions, although the significance of these functions is constantly increasing. Q15. What do you mean by the term sovereignty of state? What is the importance of sovereignty in modern times? Ans. Sovereignty. Sovereignty of states. Sovereignty is a legal term signifying the supreme power by which any state is governed. It denotes in ordinary parlance the unrestricted power of self-determination by the state of its external and domestic affairs. Austin termed sovereignty as essential, indivisible, and illimitable. As a result of the exercise of sovereignty, there emerged two legal assumptions in the domain of international law, viz., the independence and equality before the law of each sovereign state and the prohibition to interfere with the external and internal sovereignty of each independent state. The doctrine of independence of state implies that it is free to adopt any constitution it likes, is free to deal with its own citizens, either inside or outside its territories, and aliens within its territory in any manner, and is at liberty to shape its foreign policy, join any bloc or adopt a neutral attitude, conclude treaties with other states or make war or peace accordingly as it suits its interests. In the modern period, there have been revolutionary changes in the concept of sovereignty, because of which it is not proper to say that states' sovereignty is essential, indivisible, and illimitable. In the present time, states have entered into many international treaties, thereby surrendering a part of their sovereignty. For example, the members of the United Nations have accepted many obligations under the Charter. It has, therefore, been rightly remarked by Stark, sovereignty has a much restricted meaning today than in the 18th and 19th centuries, when with the emergence of powerful highly nationalized states, few limits on states' autonomy were acknowledged. At the present time, there is hardly a state which in the interest of the international community has not accepted restrictions on its liberty of action. In Union of India v. Sukumar Sengupta, AIR 1990 SC 1962 at p. 1701 Sabyasachi Mukherjee, CJ of the Supreme Court of India, quoted with approval the above observation of Stark. His Lordship added, "Any state in the modern time has to acknowledge and accept customary restraints on its sovereignty, inasmuch as no state can exist independently and without reference to other state." Under the general international law, the concept of interdependence of states has come to be accepted. Q. 16. Distinguish between A. Confederation and Federation. B. Real union and personal union. Ans. A. Confederation. A confederation or statenbund is constituted by a number of full sovereign states linking together by an international treaty into union with organs of government extending over the member states but not over the subjects of those states. They unite by means of a compact for the purpose of mutual cooperation or defense, each constituent member retaining its sovereignty and separate identity. Such a confederation is not a state. It is more or less a society of an international character, and the member states remain full sovereign states and maintain their international position. Federation. A federation or Bundesstaat, on the other hand, is a perpetual union of several sovereign states which has organs of its own and invested with power, not only over the member state, but also over their citizens. Professor Oppenheim. The ordinary powers of sovereignty are partly vested in the federal government and partly in the separate state, both the authorities being coordinate within their respective spheres. It is a real and sovereign state within the sphere of the powers granted to it, and has, unlike a confederation, direct power not only over the member states but also over the citizens of those states. The federal state has the power to declare war, make peace or conclude treaties, and the member states exercise power and control within their competence and retain a considerable measure of autonomy. B. Real union. A special form of confederation is the real union, which exists when two or more sovereign states have the same monarch and for international purposes and external relations act as one state, although the constituent elements retain their separateness in domestic matters. A real union is not itself a state, but merely a union of two full sovereign states, which together make one single but composite international person. Personal union. A personal union is in existence when two sovereign states and separate international persons are linked together through the accidental fact that they have the same individual as monarch. These states retain their separate identities for external purposes. Q. 17. Equality of states is a general principle, but there are several exceptions to the principle. Comment. Ans. Principle of the equality of states. As the members of international community, in principle, all states are equal. This equality is due to their international personality. Despite the dissimilarity in respect of their territories, population, power, civilization, prosperity, etc., all states as international persons are equal. According to Oppenheim, following are the consequences of this legal equality. I. When any question is to be decided by consent, each state is entitled to have one vote. But there are exceptions to this rule, such as the vote of the permanent members of the Security Council. 2. Legally, the importance of the votes of the weak as well strong nations is same. There are some exceptions to this rule also. 3. No state can exercise jurisdiction over another state. This rule has been applied by the courts in many cases. 4. Generally, the courts of a state cannot challenge the validity of the official acts of another state so far as these acts are related to the jurisdiction of that state. The cases of A.M. Luther and Co. v. Sugar and Co. 1921, 3 KB 532 and Underhill v. Hernandez, 1897, US 250, 18 sub. Et. 83 deserve special mention in this connection. In principle, all states are equal, but in reality they are unequals in respect of their respective powers, territory, property, etc. Oppenheim has rightly pointed out the legal equality must not be confused with political equality. The enormous differences as regards their strength are the result of their natural inequality which, apart from rank and titles, finds its expression in the province of police. Politically, states are in no manner equals. The UN Charter is based on the principle of sovereign equality of states, but in reality great powers are unequal to small states, and legally also because they possess the power of veto under the Charter. Thus the equality of states is a general principle, but there are several important exceptions of this principle. Q18. What is the difference between A. Protectorate and vassal state, B. Neutral state and neutralized state? Ans. Difference between protectorate and vassal state. Protectorate state. Vassal state. 1. A protectorate state generally entrusts its defense, external affairs, etc. to another state. 1. Vassal state is generally autonomous in its internal matters, but is completely dependent upon another her state in external matters. 2. A protectorate state remains a state under international law. 2. A vassal state is not treated a state under international law. 3. Since a protectorate state retains a sufficient measure of sovereignty, declaration of war or peace made by the protecting state with another state is not binding upon it. 3. A vassal state is bound by treaty of war or peace entered into by the state under whose international guardianship it remains. Distinction between a neutral state and neutralized state. A neutral state is a state which does not support either belligerent state during war. A neutralized state, on the other hand, is a state whose independence and territorial sovereignty is collectively accepted by an international agreement. A neutral state may at its will give up its neutrality, but a neutralized state without violation of the treaty cannot give up its neutrality. Switzerland, Belgium, Austria are some of the neutralized states whose neutrality has been guaranteed by international agreements. Switzerland is an ideal neutralized state because it has not even joined United Nations. Austria became a member of the United Nations in 1955. Stark has expressed the view that a neutralized state may become a member of the UN because under Article 48, the Security Council may exempt a neutral state from giving support in any enforcement action. The view of Stark is only partly correct because the membership of the UN invariably and undoubtedly dilutes the neutrality at least to some extent because under Article 48, the Security Council may exempt neutral states from taking part in enforcement action, but that is not a mandatory provision. In case the Security Council decides that such a state has to support the enforcement action, the neutrality of such a state will end as regards that particular case. Q19. Discuss the international positions of A. Bhutan, B. Tibet, C. Holy See or Vatican City, D. Commonwealth of Nations. Ans. A. Bhutan. Bhutan is a protectorate state of India. It is a hilly region in northeast of Nepal. In 1949, through a treaty, Bhutan entrusted the matter of foreign affairs and defense to India. It thus became a protectorate state of India. Since a protectorate state retains a sufficient measure of sovereignty, Bhutan remains a state under international law. In 1971, Bhutan became a member of the United Nations. B. Tibet. In Simla Conference, 1914, Tibet was declared a protectorate state of China. This was further confirmed by the Treaty of 1951. China accepted Dalai Lama as the spiritual head of Tibet. Tibet was autonomous in its internal matters, but China started interfering in the internal matters of Tibet. In 1959, the situation deteriorated so much that the conflict took the form of war between China and Tibet. China ruthlessly suppressed the movement of the people and Dalai Lama was compelled to leave Tibet. He fled away from Tibet and took asylum in India. China criticized action of India in granting asylum to Dalai Lama and claimed that it was an interference in her internal affairs. At its very face, this argument is absurd because, as a sovereign state, India was within her rights to grant asylum to Dalai Lama and his followers within her territory. C. Holy See or Vatican City. Holy See or Vatican City is a place where Pope resides. In the middle of 19th century, the rulers of Italy seized the territory of Pope and occupied his capital Rome. He, therefore, fled to his residential place called Vatican City. In 1871, Italy granted some guarantees to Pope. Next important change took place in 1929 when a treaty was concluded between Pope and Government of Italy. Vatican City, comprising of 100 acres of land, was accepted as a state and Pope was treated as a sovereign of this state. The present position of Vatican City is that it is an international person and possesses all the rights and duties of a sovereign state. D. Commonwealth of Nations. Commonwealth of Nations is an association of those states, except Britain, which were at some time the colonies of the British Empire. Britain, Canada, Austria, Cyprus, Nigeria, New Zealand, India, Pakistan, Ceylon, Malaysia, Singapore, etc. are its members. Before 1948 it was called the British Commonwealth of Nations. In 1948 the term British was dropped. It is now called the Commonwealth of Nations. All the members of the Commonwealth of Nations are now sovereign states. Under international law, Commonwealth of Nations is neither a state nor a federation. It is in fact a loose association of equal and sovereign states who are members of the United Nations and have agreed to follow certain general principles. Thus, under international law, Commonwealth is not a separate independent entity. Q20. What do you know about the various theories of international law? Briefly explain. Ans. There are three main theories of international law. 1. Only states are subjects of international law. According to this view, only states are the subjects of international law. This view has been severely criticized. It fails to explain the case of Sals and pirates who have been conferred some rights under international law. But those who subscribe to the view that states are the only subjects of international law say that they are not the subjects but objects of international law. They further point out that they get these rights only through the medium of the state. In reparation for injuries suffered in the service of the UN, ICJ Rep. 1949, p. 174, the International Court of Justice rejected the proposition that states only are subjects of international law, and hence the traditional view that states only are the subjects of international law is not a rule of modern international law. It is now well settled that besides states, individuals, international organizations and certain non-state entities are also the subjects of international law. 2. Individuals alone are the subjects of international law. The chief exponent of this theory is Kelsen. According to Kelsen, both state law and international law apply on the individuals. If we make an analysis, we find that individual is at the root of all laws. Thus, there is no real difference between international law and state law. Kelsen, however, admits that the difference is simply this, that state law applies on individuals immediately or directly, whereas the international law applies mediately. It may be noted that the logic behind the views of Kelsen is very strong, and it is very difficult to disprove it, although practice of the state is just contrary. In practice, international law is generally regarded as comprising of the major part of its rules regulating the relations of state. This view seems to be a reaction of the view that only states are the subjects of international law. This is in fact a very extreme view and cannot be regarded as completely correct. Individuals are now recognized as subjects of international law, and present practice shows that international organizations and certain non-state entities are also to some extent regarded subjects of international law. 3. States are main subjects of international law, but individuals, international organizations, and certain non-state entities are also subjects of international law. This view, besides making the synthesis of the first and second views, goes a step ahead to include international organizations, certain other non-state entities as subjects of international law. This is definitely a better view than the first two views. As per this theory, equal attention is given to promoting the growth of a body of world law transcending states, and applicable on a footing of equality of individual, corporations, international organizations, and states. Conclusion: on the basis of the above discussion, it may be concluded that not only states, individuals, international organizations, and certain another non-state entities are the subjects of international law. The fact, however, remains that major part of the rules of international law deal with the intercourse of states with each other. Q21. What is the place of individual in international law? Ans. Place of individuals in international law. As pointed out earlier, individuals are also now treated to be the subjects of international law. In recent times, several treaties have been entered into wherein certain rights have been conferred and duties have been imposed upon the individuals. In this connection, following may be noted. I. Pirates. Pirates are treated as enemies of mankind under international law. Every state can apprehend and punish them. 2. Harmful acts of individuals. Under certain circumstances, states are responsible for the harmful acts of their individuals. If a person causes harm to the personal property of the ambassador of another state, then under international law the state is responsible for his act. Such persons are, therefore, given stringent punishment. 3. Foreigners. To some extent, international law regulates the conduct of foreigners. It is the duty of each state to give them those rights which it generally confers upon its own citizens. 4. War criminals. War criminals can be punished under international law. According to Nuremberg and Tokyo tribunals, since war crimes are committed by the individuals, it is by punishing them the provisions of international law can be enforced. Espionage. Espionage is a crime under international law and, therefore, spies can be apprehended and punished. 6. In addition to the above-mentioned examples, certain treaties and conventions have been entered into wherein individuals have been conferred upon the rights directly. The 1965 Convention on the Settlement of Investment Disputes between the state and the nationals of other states is a glaring example of such benign trend. 7. The International Covenant on Human Rights confers rights directly upon the individuals. These, along with the UN Commission on Human Rights, have enabled the individuals to send petitions even against their own states. Thus, slowly and gradually, individuals are occupying an important place under international law. It may therefore be concluded that individual has become a subject of international law, not having the same quality as a state, but capable of asserting rights himself before some international tribunals, although lacking procedural capacity to bring actions in most cases. The legal order will continue to be imperfect as long as it faces new challenges such as apartheid and modern technological advance, and the individual, as a subject of international law, will continue to play an important role in the development of the law. Q22. What do you mean by recognition? What are the conditions for recognizing a new state? What are the main theories of recognition? Ans. Meaning and definition of the term recognition. In the words of Professor Oppenheim, in recognizing a state as a member of international community, the existing states declare that in their opinion the new state fulfills the conditions of statehood as required by international law. Conditions for recognition of a new state. According to Kelson, a community to be recognized as an international person must fulfill the four conditions. A. The community must be politically organized. B. It should have control over a definite territory. C. This control should tend towards permanence. And D. The community thus constituted must be independent. But international law does not provide as to how those essential conditions are to be determined. International law leaves the members of international community free to determine whether the states to be recognized contain essential conditions of statehood. It is because of this reason that recognition is very often said to be a political diplomatic function. Theories of recognition. There are two main theories of recognition. One, constitutive theory, and two, declaratory or evidentiary theory. 1. Constitutive theory. According to Oppenheim, a state is and becomes an international person through recognition only and exclusively. According to this theory, recognition clothes the recognized state with duties and rights under international law. Recognition is a process through which a political community acquires international personality by becoming a member of the family of nations. Hegel, Angelotti, Holland, Oppenheim, etc. are the chief exponents of this theory. Judge Lauterpacht has written that there is a legal duty on the part of the states to recognize any community that has in fact attained statehood. As pointed out by P. Corbett, according to the constitutive theory, statehood and participation in the international legal order are attained by political groups only insofar as they are recognized by established states. This theory does not conform to the practice of states. In practice, most of the states accept the declaratory theory. Criticism. This theory has been severely criticized by many jurists. In practice, states do not accept any obligation to recognize a community that has attained statehood, although they may normally recognize it. According to this theory, unrecognized state can have neither rights nor duties under international law. This is a very absurd suggestion. 2. Declaratory theory. According to this theory, statehood or the authority of the new government exists as such prior to and independently of recognition. Recognition is merely formal acknowledgement through which established facts are accepted. The act of recognition is merely declaratory of an existing fact that a particular state or government possesses the essential attributes of statehood as acquired under international law. The chief exponents of this theory are Hall, Wagner, Brierly, Pitt Corbett, and Fisher. Brierly has remarked that the granting of recognition to a new state is not constitutive, but a declaratory act. A state may exist without being recognized if it exists in fact, then whether or not it has been formally recognized by other states, it has a right to be treated by them as a state. Criticism. This theory has also been subjected to criticism. The view that recognition is only a declaratory of an existing fact is not completely correct. In fact, when a state is recognized, it is a declaratory act. But the moment it is recognized, there ensue legal effects of recognition, which may be said to be of constitutive nature. Conclusion. On the basis of the above discussion, it may be concluded that recognition is declaratory as well as constitutive. As pointed by Stark, the truth lies somewhere between the two theories. Oppenheim has also admitted that recognition is declaratory of an existing fact but constitutive in nature. To conclude, in the words of Professor Briggs, juridical theories of recognition deduced from jurisprudential concepts fail to explain the facts of state conduct, and induction from state conduct have failed to provide a judicial, unambiguous theory of recognition. Q23. What are the modes of recognition? Distinguish between de facto and de jure recognition. Ans. Modes or kinds of recognition. Following are the two kinds of recognition. 1. De facto recognition and 2. De jure recognition. 1. De facto recognition. As pointed by Professor Schwarzenberger, when a state wants to delay recognition de jure of any state, it may, in the first stage, grant de facto recognition. De facto recognition is given because it is doubted that the state recognized may not be stable or it may not be able and willing to fulfill its obligations under international law. De facto recognition means that the state recognized possesses the elements of statehood and is fit to be a subject of international law. According to Professor Oppenheim, the de facto recognition of a state or government takes place when, in the view of the recognizing state, the new authority, although actually independent, has not acquired sufficient stability or does not yet offer prospects of complying with other requirements of recognition such as willingness or ability to fulfill international obligations. Further, de facto recognition is in a sense provisional and liable to be withdrawn if the absent requirement of recognition fails to materialize. Under de facto recognition, diplomatic relations are not established. 2. De jure recognition. De jure recognition is granted when, in the opinion of the recognizing state, the recognized state or its government possesses all the essential requirements of statehood and is capable of being a member of the international community. As pointed out by Professor H. A. Smith, the British practice shows that three conditions precedent are required for the grant of de jure recognition of a new state or a new government. The three conditions are: A. A reasonable assurance of stability and permanence. B. The government should command the general support of the population. And C. It should be able and willing to fulfill its international obligation. Distinction between de facto and de jure recognition. As pointed out by Schwarzenegger, de facto recognized is by nature provisional and may be made dependent upon conditions which the new entity has to comply. It differs from de jure recognition in that there is not yet a formal exchange of diplomatic representatives. De jure recognition is complete, implying full and normal diplomatic relations. In Luther v. Sagar, 1921, 3 KB 532, it was held that there is no distinction between de facto and de jure recognition for the purpose of giving effect to the internal acts of the recognized state. The majority of the jurists agree that so far as legal effects are concerned, there is hardly any distinction between the two types of recognition. If at all there is any difference between two types of recognition, it is chiefly political rather than legal. Q24. What do you mean by recognition of insurgency? What are the effects of such recognition? Ans. Recognition of insurgency. Insurgency presupposes a civil war or political revolt in a state. In fact, insurgency is an intermediate stage between tranquility and belligerency. Essential conditions for recognizing insurgents. Following are the essential conditions for recognition of insurgency. 1. Control over a considerable part of the territory. 2. Considerable support to the insurgents from the majority of the people living in the territory. And 3. Insurgents should be capable and willing to carry out international obligations. Effects of recognition of insurgency. Following are the effects of recognition of insurgency. 1. Insurgents are not treated as pirates. 2. The rebels of civil strife are treated as hostis generis humani, the enemy of human beings, until they are recognized as insurgents. 3. The international rules of war become applicable to them. Q. 25. What factors will govern the recognition of belligerency by a third state? What is the effect of such recognition? Ans. Recognition of belligerency. On the outbreak of rebellion or insurrection in any country, the outside powers generally maintain an attitude of non-interference in the domestic affairs of that state. However, it may frequently render it not possible for other states to maintain an attitude of indifference, either because the rebellious forces are in effective occupation of a large part of the territory of the parent government, or the actual war between the parent government and the rebellious forces has reached a stage when outside powers will not treat it merely an intermediate struggle. In such cases, the political communities struggling to attain a condition of separate statehood are accorded a de facto recognition of belligerency pending the determination of the question whether they are formally admitted to membership or are formally brought back to subjection. Recognition of belligerency is a question for the executive department of the government, whose declarations are binding on the court. Such recognition is a question of policy and not of law. It depends on various considerations, example, whether the belligerent community has an organized government capable of carrying on war according to recognized rules and methods, whether there exists actual war at time, and whether the interests of the state conceding such recognition are being affected by the outbreak of war. Effect of recognition. Recognition, besides conferring rights, imposes duties on the insurgent, viz., the establishment of price codes and issue of lists of contraband. Insurgents can, therefore, be recognized belligerents only if they are capable of fulfilling their obligations to other states. The recognizing state becomes entitled to neutral rights, which are respected by rival parties. Such recognition protects the belligerents from being treated as traitors on land or pirates on the sea. It also grants immunity to the parent state for acts of omission and commission on the part of the belligerents detrimental to the recognizing states. Recognition of belligerency confers an international status on the belligerents for purposes of war. Although there is no exchange of embassy or the conclusion of a treaty, yet consuls are generally exchanged for the protection of commercial interests. The recognizing state also recognizes within its jurisdiction the flag of the revolted government and the commissions it issues. Q. 26. What do you mean by state succession? Define its kinds. Ans. Definition. Oppenheim has described state succession in the following words. A succession of international person occurs when one or more international persons take place of another international person, in consequence of certain changes in the latter's conditions. State succession. There is a succession of states where the territory of one state passes from its supremacy to that of another. A state may succeed another state by incorporating a certain portion of the latter's territory. It may be split up into two or more states, or new states may emerge out of the territory of a dismembered state, as happened to the territory of Austro-Hungarian monarchy as a result of the First World War, or to the territory of German Reich as a result of the Second World War. In other words, the succession of state implies the substitution of one state for another. The succession is of two kinds, viz., universal and partial. Universal succession. There is universal succession. When one state is completely absorbed by another as a result of annexation or conquest, i.e., the South African Republic was annexed by Great Britain in 1900, Korea by Japan in 1910, and Abyssinia by Italy in 1936. 2. When several states agree to merge into a federal state or union. Example, in 1871 the German states united together to form the German Empire. The merger of Egypt and Syria on the 22nd February 1958 and later Yemen on the 22nd March 1958 to form the United Arab Republic of Egypt and Syria, or the merger of Iraq and Jordan on the 14th February 1958 to form the Arab Federal State, and 3. When one or more states are formed or one or more international persons take the place of another international person by division of a former single state or international person, each of the independent states being a successor state, e.g., the division of India into India and Pakistan in 1947. Partial succession. Partial succession arises by succession, when another state is established by a part of the territory breaking off from the parent state and thereby gaining independence. Example, the separation of the United States from the parent state Great Britain in 1776. 2. By cession or conquest, when one state acquires a part of the territory of another state and assumes sovereignty over the portion ceded. Example, cession of California to the United States in 1847. 3. By dismemberment, when a full sovereign state loses part of its independence through incorporation into a federal state or coming under the suzerainty or protectorate of a stronger power, or when a not full sovereign state, i.e., a suzerain or protectorate or even a member of a federal state, becomes full sovereign. Example, Czechoslovakia was dismembered in 1938 as a result of the Munich Agreement. There is a considerable body of authority among the text writers inclined to the view that the successor state is bound by the contracts of the extinct state. The new state becomes liable for all local debts and contractual obligations. The earlier view as laid down by an English court in West Rand Central Gold Mining Co. Limited v. Rakes that the sovereign of a conquering state was not bound by the obligations incurred by the conquered state has undergone substantial change, and modern practice has tended to modify the rigidity of this doctrine of non-succession. The Permanent Court of International Justice in the German settlers case held that private rights acquired under existing law, including those acquired from the state as the owner of the property, are valid as against a successor in sovereignty, i.e., they do not cease on a change of sovereignty. The successor state is, however, justified in refusing to own the obligations of the ceded state which the latter incurred for the purpose of war against the former. Contracts, however, purely personal to the extinct state, do not survive purpose distinctly against the interests of the inhabitants of the territory transferred or contracted for financing of wars or other hostile undertaking against the successor state. Arrangements with respect to public debts are usually made in treaties. 6. Torts. The succeeding states are under no liability for the delicts of the extinct state. The Robert E. Brown claim. 7. Succession to property lying in foreign state. The successor state may claim any state property in the territory over which it acquires sovereignty. 8. Laws. The civil law of the former sovereign continues unless changed by the successor state. Public law, however, changes simultaneously with the transfer of sovereignty. Whatever public law continues to remain in operation after a territorial transfer derives its force as a positive law owing to its acceptance by the acquiring state. 9. Nationality. As regards nationality, the inhabitants of the ceded or vanquished territory become subjects of the annexing state and lose citizenship of the former state. Usually a certain period of time is allowed to the inhabitants to elect for themselves as to which state they want to owe their allegiance. Q27. As a result of civil war, a province secedes from the parent state and is recognized as independent. Consider the effect of this on a. The public debt of the parent state, b. Treaty rights and obligations binding the parent state, and c. Mining concessions in ex granted by the parent state to subjects of other powers. Ans. Secession from parent state. In the absence of treaty or in so far the provisions of the treaty may not extend, the following consequences ensue. A. The new state X will become liable for all debts locally connected with such territory. Example, debts charged on local revenues or on revenues charged on property situated within the territory. The new state will not incur any legal liability to the general debts of the parent state, unless otherwise provided for by the treaty. B. The new state X will not be liable under, or entitled to, any personal treaties relating exclusively to the persons of the contracting parties, example, treaties of alliance, arbitration, or neutrality. But it will succeed to any treaties specifically relating to the territory comprised in the new state, such as treaties relating to the boundary or regulating the navigation of rivers flowing through its territory. C. The succeeding state is obliged to respect the concessionary rights which were legitimately conferred by the parent state. Such concessionary rights, especially the mining concessions, can be regulated and modified by the new state within its legislative competence so far as it relates to aliens and deal with them at its discretion. Q28. As a result of the pressure of war X, a part of the state Y is ceded to Z, another neighboring state. Discuss its consequences on A. The public debt of the ceded part 10. B. Treaties and political obligations binding the ceded part. C. Mining concessions in the territory of the ceded part granted to aliens. And D. An injury in the nature or a tort or delict committed by an official of the ceded part affecting an alien. Ans. Cession of territory. In the case of cession of territory, the question of succession is generally dealt with in a treaty, but in its absence the following are the rights and obligations to the transferred state. Two contingencies may arise in the case. If the government of the absorbing state be a federal state not annexing X as an integral portion of its territory, and maintaining the internal sovereignty of the constituent states, X will retain its internal sovereignty and the rights and obligations of X will inhere in the part ceded. But such debts or obligations will be enforceable only through the government of the Union. Treaties inconsistent with the terms of the federal state will extinguish, but personal treaties, example, extradition treaties, may remain operative if not inconsistent with the central government or not denounced by it. If, however, the absorbing state Z is a united government so as to completely extinguish the identity of X, the consequences will be A. The absorbing state will be liable for all civil obligations, including the public debt of the ceded part without regard to the value of the assets received. B. Treaties and political obligations binding the ceded part will not be enforceable except treaties locally connected with the territory of the part absorbed. C. Mining concessions granted to foreigners in the ceded part will not be binding on the state. D. The succeeding state is under no liability for the delicts of the extinct state. West Rand Central Gold Mining Co. v. The King, 1905, to KB 391, and Robert E. Brown Claim, American Journal of International Law, 1926, Volume 20, p. 328. Q29. What do you understand by intervention? State briefly the just grounds for intervention. Or, in what circumstances may a state exercise its right of intervention to protect persons, property and interests of its subjects abroad? Ans. Intervention. Oppenheim calls intervention as dictatorial interference by a state in the affairs of another state for the purpose of maintaining or altering the actual condition of things. Mere friendly advice and general political influence do not strictly come under this term, as the essential requisite of intervention, viz., use of force or a threat to use force, is lacking in them. Kinds of intervention. There are three different kinds of intervention, viz. 1. Internal. It is the interference by one state between disputing sections of the community in another state either for protection of the legitimate government or the insurgents. 2. External. It is the intervention by one state in the relations generally of the hostile relations of other states. It is, in other words, an intervention in the foreign affairs of another state, such intervention being directed against hostile relations of such state. 3. Punitive. It is a punitive measure falling short of war, and is in the nature of a reprisal for an injury suffered at the hands of another state. Legal occasion of intervention. According to Professor Briefly, the strictly legal occasion of an intervention may be brought under three heads, viz., self-defense, reprisals, and the exercise of a treaty right. There are few interventions which can be justified by right, and as such are not violations by the intervening state of the independence of another. They are discussed below along with other grounds which may not afford a reasonable justification for intervention. 1. Self-preservation. The supreme interest of the state overrides law. The right of self-preservation is more sacred than the duty of respecting the independence of other states. A state has a right to interfere in the affairs of another state where the security and immediate interests of the former are compromised. Interventions, therefore, in order to ward off imminent danger to the intervening state are justified by the force of circumstances. The danger must be direct and immediate, not contingent and remote. Further, the immediate cause for intervention must be sufficiently important to justify war. And, lastly, the necessity of self-defense must be instant, overwhelming, leaving no choice of means and no time for deliberation. The Caroline. 2. Enforcement of treaty rights. A state is justified in interfering in the affairs of another state if the provisions of any treaty oblige the former to preserve the independence or neutrality of the latter. Such intervention does not violate any right of independence because the state that suffers has conceded such liberty of interference by treaty. Invitational intervention. As regards invitation by the lawful government of the state to intervene in its internal affairs, the matter is not free from difficulty. It is again highly controversial whether the invitation from the government could be legitimately regarded as from the lawful government in such cases. The most conflicting intervention has been the involvement of the United States and other states in the Vietnamese conflict. Although many writers, notably American, have justified the United States intervention in that conflict as a lawful intervention, it cannot be denied that the civil war in that case had been sponsored, aided and promoted by the United States of America, much to the woe of Vietnamese. This intervention may be said to be the outcome of the policy of maintenance of balance of power in the region. 3. Grounds of humanity. Another justification for intervention is based on the ground of humanity. Lawrence observes that in the opinion of many writers such interventions are legal, but they cannot be brought within the ordinary rules of international law, which does not impose on the state the obligation of preventing barbarity on the part of their neighbors. The barbarities committed in East Bengal by the government of Pakistan in the name of a united Pakistan following a civil war towards the end of March 1971 were unprecedented, and in spite of the loud proclamations of the United Nations, established with the pious object of saving succeeding generations from the scourge of war and establishing conditions under which justice and respect for the obligations arising from the international law can be maintained, it did not take cognizance of the serious situation encompassing East Pakistan until the breaking out of war between India and Pakistan in the early part of December 1971, when also it completely ignored the basic cause of Bangladesh tragedy. The brutal and unprovoked killings by West Pakistani forces and barbarities were in the teeth of the provisions of the Convention on the Prevention and Punishment of the Crime of Genocide, 1948. 4. Intervention to prevent illegal intervention. Intervention undertaken for the purpose of prevention or ending illegal intervention on the part of another state is regarded lawful. 5. Balance of power. Preservation of the balance of power has been an undoubted maxim of European diplomacy from the middle of the 17th century. It is condemned by jurists of all ages. 6. Protection of persons and property. Protection of the persons, property and interest of its nationals abroad or defense of national honor may provide justification for intervention. The necessity for protection may arise due to gross injustice or due to injury caused by unfair discrimination. Such persons are primarily subjects to the local law, but they may claim their own state's protection on account of unworthy treatment. Such right of intervention is afforded on the ground of international comity and tolerance with which a state is expected to comply. 7. Collective intervention. Collective intervention pursuant to Chapter 7 of the Charter undertaken under the authority of the Security Council may afford another reasonable ground of intervention. Q. 30. That intervention is, as a rule, forbidden by the law of nations which protects the international personality of the states, there is no doubt. On the other hand, there is just as little doubt that this rule has exceptions. Oppenheim. Discuss and illustrate the foregoing statement. Ans. Intervention. Professor Oppenheim observes that intervention is, as a rule, forbidden by the law of nations, but there are circumstances where interventions take place by right, and still there are cases where, although they do not take place by right, are nevertheless admitted by the law of nations, and are excused in spite of the violation of the personality of the respective states which they involve. Right or intervention. Oppenheim mentions 7 reasons when a state may have a right of intervention against another state, viz. 1. A state which holds a protectorate has a right to intervene in all the affairs of the protected state. 2. If an external affair of a state is at the same time by right of an affair of another state, the latter has a right to intervene, in case the former deals with that affair unilaterally. 3. If a state which is restricted by an international treaty in its external independence, or its territorial or personal supremacy does not comply with the restrictions concerned, the other party or parties have a right to intervene. 4. If a state in time of peace or war violates such rules of the law of nations as are universally recognized by custom or are laid down in law-making treaties, other states have a right to intervene and to make the delinquent submit to the rules concerned. 5. A state that has guaranteed by treaty the form of government of another state, or the reign of a certain dynasty over the same, has a right to intervene in case of a change of form of government or of dynasty, provided that the treaty of guarantee was concluded between the respective states and not between their monarchs personally. 6. The right of protection over citizens abroad, which a state holds, may cause an intervention by right to which the other party is legally bound to submit. 7. Finally, the Covenant of the League of Nations provided, as does the Charter of the United Nations, for the collective intervention of the member states for the purpose of restraining states which disturb the peace of the world by resorting to war or force generally or to threats of force in breach of the provisions of the Covenant. In contradistinction to intervention by right, Professor Oppenheim observes, there are other interventions which cannot be considered illegal, although they violate the independence or the territorial or personal supremacy of the state concerned, and although such state has by no means a legal duty to submit patiently and suffer the intervention. They are of two kinds, viz., intervention in self-preservation and intervention which is necessary in the interest of the balance of power. Q. 31. Write short notes on A. The Monroe Doctrine, B. Drago Doctrine, and C. The Brezhnev Doctrine. Ans. A. The Monroe Doctrine. The doctrine embodies a principle of American policy enunciated by President Monroe of the United States in 1823, declining any European intervention in political affairs of the American continent. It was never affirmed by Congress nor made the subject of a treaty, and as such is not a rule of international law. The declaration was to the following effect. 1. The American continents, by the free and independent condition which they have assumed and maintained, are henceforth not to be considered as subjects for future colonization by any European powers. 2. In the wars of the European powers, in matters relating to themselves, we have never taken any part, nor does it comport with our policy to do so. 3. The United States had not intervened, and never would intervene, in wars in Europe, but they could not, on the other hand, in the interest of their own peace and the happiness, allow the allied European powers to extend their political system to any part of America, and to try to intervene in the independence of the South American republics. We should consider any attempt on their part to extend their system to any portion of this hemisphere as dangerous to our peace and safety. The Monroe Doctrine, as observed by Oppenheim, is largely of political and not legal character. It established a fundamental principle of American policy by declaring that there must be no territorial agreement by any non-American power on American soil and also embodying the non-intervention by the United States in European policies. It asserts a claim of political hegemony by USA over the whole American continent. B. Drago Doctrine. The Foreign Secretary of the Republic of Argentine, Luis M. Drago, in 1902, at the time when Venezuela had been pacifically blockaded by Great Britain and Germany, on behalf of their nationals, expressed the opinion that a state should not have recourse to armed force for the recovery of contract debts claimed from the government of one country by another as being due to its subjects. He observed that the failure of a state to make payment of its public debt did not give rise to the right of intervention. Drago's objections were confined to the use of armed force in the collection of public debts only. This view was incorporated in the Second Hague Convention, 1907, but was qualified by the addition that armed intervention could apply when the debtor either refused arbitration or failed to submit to the award. C. The Brezhnev Doctrine. The communist countries, notably the USSR, have evolved a new socialist international law overriding the conventional law which takes into account new developments in international relations. Lenin first propounded this theory in February 1918 by stating that the interests of socialism are higher than the interest of the right of nations to self-determination. The doctrine which bears the name of the author was propounded by Elie Brezhnev, General Secretary of the CPSU, at the 5th Congress of the Polish Communist Party on 12 November 1969, which affirms that when internal and external forces hostile to socialism attempt to turn the development of any socialist country in the direction of the restoration of the capitalist system, there is a threat to the security of socialist Commonwealth as a whole. This doctrine has received trenchant criticism from independent nations. The USSR's intervention in Czechoslovakia in August 1968 was deplored by all right-thinking people of the world and only proved that, until a more equitable order was established, the smaller states would only serve as factors in the grand design of the superpowers. Q. 32. What do you mean by territorial jurisdiction? What are the limitations on territorial jurisdiction? Ans. Territorial jurisdiction. Jurisdiction of a state over its territory is called territorial jurisdiction. It implies that a state enjoys civil as well as criminal jurisdiction over all persons and things within the territory of a state which falls under its territorial jurisdiction. The principle of territorial jurisdiction extends to land territory within boundaries, internal waters, territorial sea, airspace above the land territory, and subsoil under earth. To exercise jurisdiction by state over its territory is a right of state. Limitations on territorial jurisdiction. It is to be noted that a state has an exclusive jurisdiction over the territory. However, exclusive jurisdiction of a state within its own territory is not absolute. Certain limitations have been imposed upon the rule of territorial jurisdiction, which have developed partly through customs and partly by the conclusion of treaties. 1. Diplomatic agents. Diplomatic agents enjoy privileges and immunities from the civil and criminal jurisdiction of the receiving state. Since a long time, there appears to be general agreement that a diplomatic agent, during the term of his office, is totally exempt from both criminal and civil jurisdiction in the state where he is accredited. 2. Embassies. Embassies situated in other states are immune from the jurisdiction of the state. The agents of the state cannot enter in the foreign embassies except with the consent of the head of the mission. 3. Foreign sovereigns. Foreign sovereigns enjoy immunities and they are exception to the principle of territorial jurisdiction. No local jurisdiction, whether criminal or civil, could be exercised over them. Under general international law, immunity granted to foreign sovereigns includes immunities to head to states, Prime Minister, ministers residents acting in their official capacity, ministers, departments, agencies and offices. 4. Property of foreign sovereigns. The property of the foreign sovereigns remains immune from the jurisdiction of the state. As long as the foreign sovereign has some interest in the property, it remains immune, and it is immaterial for what purpose the property was employed. 5. Foreign armed forces. Armed forces of a state remain in the foreign territory on several occasions in the service of their home state. Such forces are considered by some to be extraterritorial, and therefore they remain under the jurisdiction of the state to which they belong. Q. 33. Discuss international rivers and inter-oceanic canals. Or writ short notes on I. Suez Canal, 2. Kiel Canal, 3. Panama Canal. ANS. Maritime territory beyond inland waters. The sovereignty of a coastal state extends to maritime belt or territorial waters. Besides territorial waters, the coastal state also exercises sovereign rights, for certain limited purposes, over continent held, exclusive economic zone and contiguous zone. Each of these maritime zones has been briefly discussed in a separate chapter entitled The Law of the Sea. International rivers. Rivers which run through several states are described as non-national rivers. Such rivers are owned by more than one state. Each state owns that part of the river which runs through its territory. Rivers which are navigable from the open sea and pass through several states, between their sources and mouths, are called international rivers. They are termed international because freedom of navigation in time of peace on all such rivers in Europe and on many of them outside Europe for merchantmen of all nations is recognized by conventional international law. As regards the utilization of flow of waters of non-national and international rivers, Oppenheim has pointed out that it is not within the arbitrary power of one of the riparian states, for it is a rule of international law that no state is allowed to alter the natural conditions of its own territory to the disadvantage of the natural conditions of the territory of a neighboring state. Reference may also be made here to the Indus Waters Agreement signed on 19 September 1960 by India, Pakistan, and the International Bank for Reconstruction and development for regulating the use of the waters of Indus, Chenab and Jhelum rivers. This further confirms that in the absence of a treaty or agreement there can be no definite obligation of a riparian state in respect of the use of waters of a river. Inter-Oceanic canals. Inter-Oceanic canals are the canals which connect international waterways and are available for the shipping of all states. Their use and control are governed by international treaties. The most important of oceanic canals are the following. 1. Suez Canal. It is the most famous interoceanic canal. In the beginning, it was under the control of French government. Later on, it came under the control of British government in 1954. A treaty was concluded between British and Egypt whereby Britain withdrew its forces from the Suez Canal. In 1956, Suez Canal was nationalized by Egypt. France, Britain and Israel reacted strongly against this action of Egypt and made a joint armed intervention to prevent Egypt from nationalizing the Suez Canal. The problem was resolved through the efforts of Russia, Security Council and the General Assembly. Subsequently, an agreement was entered into whereby it was provided that the Suez Canal remain aloof from international politics, and all the states shall have the right of shipping over this canal. However, Egypt would be entitled to realize taxes from the ships passing through the canal. In the Arab-Israel conflict, the canal was greatly damaged and had to be closed for several years. After the ceasefire between Israel and Egypt, the latter cleared the canal. But later on it was again opened for shipping etc. by states. 2. Kiel Canal. It is another important interoceanic canal connecting Baltic Sea and North Sea. In the beginning this canal was under the control of Germany. After the First World War, it was thrown open for all the states. A leading case relating to Kiel Canal is SS Wimbledon, PCJI, 1923, Series A, Number 1, WCR 163. In this case, the Permanent Court of Justice held that the canal should remain open for all the states who are not at war with Germany. If some states are on war and Germany remains neutral in that war, even then the canal should remain open for such states. The facts of this case are as follows. On 21st March 1921, the German authorities stopped a British ship named SS Wimbledon on the ground that it contained military equipments being shipped to Poland, who was at war at that time with Russia. The German authorities contended that allowing the ship to pass through the Kiel Canal would amount to violation of the German neutrality. The prominent Allied nations filed case against Germany in the Permanent Court of International Justice. Deciding in favor of the Allied nations, the World Court held that under Article 380 of the Treaty of Versailles, Germany was bound to allow the passage through Kiel Canal to the SS Wimbledon. The court, therefore, ordered that Germany should pay compensation for violation of its treaty obligations. 3. Panama Canal. Panama Canal connects Atlantic Sea with the Pacific Sea. Under the Treaty of 1901, the Panama Canal came under the control of United States of America. This is a very important canal for commercial and transport purposes. Recently, there has been a lot of controversy between Panama and America regarding the control and use of this canal. In March 1973, the Security Council held a session on Panama. In the said session, a proposal was brought which could have removed the control of America over this canal. But this proposal was vetoed by America. America, however, expressed desire to enter into fresh treaty with Panama in connection with the use and control of this canal. Subsequently, Panama and the United States agreed on certain principles regarding the use and control of the canal, and on the basis of the said principles, they hope to enter into a treaty in near future. After prolonged negotiations for more than 3 years, the USA and Panama finally signed on 7 September 1977 to treaties. A treaty guaranteeing the permanent neutrality of the canals, and 2. A basic treaty governing the use and defense of the canal through December 1999, changing the status of the Panama Canal. One of the two treaties provides that the USA will turn over control of the canal and the canal zone to Panama by the end of this century. The other treaty allows the USA to defend the strategic waterway if needs be, for an indefinite period. The treaties guarantee the permanent neutrality of the canal. Q34. What are the various modes of acquiring territories? Discuss with relevant case. Ans. Modes of acquiring territories. Following are the modes of acquiring territories under international law. 1. Occupation. According to Stark, occupation consists in establishing sovereignty over a territory not under the authority of any other state, whether newly discovered or in unlikely case abandoned by the state formerly in control. A leading case regarding occupation is Island of Palama's arbitration, 1929, award of the Permanent Court of Arbitration, 1929, Heinsohn case p. 361, see also Agil, Wall, 1968, pp. 867 to 912. In this case there was a dispute between America and Netherlands over the island of Palamas. America claimed to have acquired it under a treaty of 1898 with Spain. This island was discovered by the Spaniards. On the other hand, Netherlands claimed to have occupied it since 1700. According to the Court of Arbitration, Island of Palamas was a part of Netherlands because although it was discovered by Spaniards, they never occupied it and established contracts with the inhabitants of the island. Thus, for occupation of a territory, it is not sufficient to have an intention to establish sovereignty over the territory concerned. It is also necessary to make some actual exercise of such authority. 2. Prescription. Yet another mode of acquiring territory is by prescription. In words of Stark, title by prescription is the result of peaceable exercise of de facto sovereignty for a very long period over a territory, subject to the sovereignty of another state. But international law does not prescribe any fixed period for prescription. As pointed out by an eminent writer, D.H.N. Johnson, a state may acquire some territory by prescription only when the following conditions are fulfilled. I. When it has not accepted the sovereignty of any other state over the said territory. 2. Possession should be peaceful and uninterrupted. 3. Possession should be in public. 4. Possession should be for a definite period. D.H.N. Johnson, Acquisitive Prescription in International Law Bible. Wall 6 VII, 1950, p. 332 at pp. 335, 344 to 347. It may, however, be noted that in the presence of some treaty or convention, territory cannot be acquired by prescription through administrative acts only. See Frontier Lands Case, Belgium Netherlands, ICJ Rep. 1959, p. 209. Temple of Preah Vihear, Marits, Cambodia v. Thailand, ICJ Rep. 1962, p. 6. 3. Accretion. As pointed out by Stark, title by accretion occurs when new territory is added mainly through natural causes to territory already under the sovereignty of the acquired state. No formal act or assertion of title is necessary. 4. Cession. Territory may also be acquired through cession. It may either be a voluntary act or in consequence of a war. Cession is generally considered valid only when the sovereignty of the territory concerned is transferred to another state. In Re. Berube Union and Exchange of Enclave, AIR 1960 SC 845 at pp. 856 to 57, the Supreme Court of India observed, it is an essential attribute of sovereignty that a sovereign state can acquire foreign territory and, in case of necessity, cede a part of its territory in favor of a sovereign state, and this can be done in exercise of its treaty-making power. Cession of national territory in law amounts to the transfer of sovereignty over the said territory by the owner state in favor of another state. This power, it may be added, is of course subject to the limitations which the constitution of the state may either expressly or by necessary implication impose in that behalf. In Union of India v. Sukumar Sengupta, AIR 1990 SC 1692. Popularly known as Tin Bigha case. Tin Bigha area was given to Bangladesh by India under the 1974 and 1983 agreements to connect Dehgram with Panbari Mauja, S. Patram, of Bangladesh. As per agreement, lease in perpetuity was given over the area at the rate of Rs. 1/2 per annum, but the Government of India waived its right to charge such rent in respect of the leased area. The agreement provided that sovereignty over the leased area shall continue to vest in India. Delivering the judgment, Sabyasachi Mukherjee, CJ, observed, a fortiori, the said transaction did not amount to cession of the said area of Tin Bigha in favor of Bangladesh. Cession as understood in international law would result in an actual and physical transfer of the said area to Bangladesh, following which Bangladesh would have the exclusive right to treat the said transferred territory as part of its own territory and exercise full control, dominion and right over the same. This is not the position or the situation which is contemplated under the agreement. The rights intended to be conferred on Bangladesh under the said agreements would amount to what is known as servitude in international law, AIR 1990 SC 1692, at p. 1706. Q. 36. What are the various modes of loss of territory? Ans. Modes of loss of territory. Following are the modes through which a territory may be lost. 1. Cession. As one state acquires the territory through cession, the other state loses it. 2. Operation of nature. Sometimes a state may lose its territory through the operation of nature such as earthquake, etc. 3. Subjugation. A state may acquire territory through the operation of nature. 4. Prescription. When a state occupies a particular territory for a long period, then it is entitled to acquire it through prescription. On the contrary, the state which had occupation over it earlier may lose it. 5. Revolt. Sometimes a state may lose its territory and a new state may emerge. For example, as a result of revolt, Pakistan lost the territory of East Pakistan and a new state of Bangladesh emerged. 6. Dereliction. When a state renounces a part of its territory or fails to exercise or slackens to exercise sovereignty over it, then it may lose such territory. Such examples are, however, very rare in history. 7. Losing a territory by granting of independence to a colony. Britain, France and other imperialist states lost territories during last few decades by granting independence to colonies or otherwise acquiring of independence by the colonies. Q. 37. Discuss the accession of Kashmir in the light of international law. Ans. Legal implications of the accession of Kashmir. Jammu and Kashmir, the northernmost state of India, borders on the USSR, Sinkian and Tibet in the north and northeast and Pakistan on the west and southwest. Before the dawn of independence, Kashmir, like other Indian states, was directly under the suzerainty of His Majesty the King of England. With the passing of the Independence Act, 1947, by the British Parliament transferring power to Indian hands, there lapsed the suzerainty of the Crown over the Indian states, and the Indian states were left free to join either the Indian Dominion or the Dominion of Pakistan. The ruler of Kashmir was at liberty to choose the future constitutional status of the state. Shortly after the conclusion of the standstill agreement with Pakistan for the continuance of the economic and administrative relations as also to maintain communications, supplies, etc., on the same basis as existed before the partition of India, the government of Kashmir complained that the Pakistan authorities were withholding supplies of commodities like food grains, salt, sugar and petrol by denying transport facilities. This conduct on the part of the government of Pakistan gave ground for a legitimate apprehension that pressure was being brought on Kashmir for its accession to Pakistan. The strong economic pressure resorted to by Pakistan in the beginning later assumed the form of a full-scale blockade against Kashmir. In September 1947, there was concentration of tribesmen at the northwest frontier province, who along with the western Punjab Muslims, trekked into the villages on the border of Kashmir and committed loot, arson and murder. The Kashmir government lodged a strong caveat with the government of Pakistan through whose territory the raiders entered Kashmir, but it was of no avail. The raiders were highly organized and soon they occupied a large portion of Kashmir territory in the Poonch area and threatened the occupation of Srinagar. This mass invasion of tribal people, aided and abetted by Pakistan, placed the government of Kashmir in a very difficult predicament. They felt that they were unequal to the task, and without outside assistance they could not resist the tribal onslaught on the independence of their state. Accordingly, the Maharaja of Kashmir appealed to the government of India for military aid. India had no jurisdiction to intervene in the internal affairs of the Kashmir state without its accession to India. To overcome the difficulty, on the 26th of October, 1947, the Maharaja, in concurrence with Sheikh Abdullah, President of the National Conference, offered to accede the state of Kashmir to India. The Indian Independence Act, 1947, did not provide for the consultation of the wishes of the people of the princely states in order to determine the question of accession to either dominion, and as such India was free to accept the offer of the Maharaja of Kashmir acceding the state to India as final. On the 27th October 1947, India accepted the accession of Kashmir, by which Kashmir became an integral part of India. But for political rather than constitutional reasons, India volunteered that the accession should be subject to a plebiscite of the people to be held after the restoration of normal conditions in the state. The Indian Prime Minister observed that India could not finalize anything in a moment of crisis and without the fullest opportunity being given to the people of Kashmir to express their wish. It is, however, to be noted that above declaration by the Prime Minister of India was made after the acceptance of the accession, and accession was not made subject to that condition. In February 1954, the Kashmir Constituent Assembly finally decided to accede to the Indian Union, thus ending a state of suspense, instability and uncertainty which impeded the progress of the people of Kashmir. It is often argued that after 15 August 1947, the state of Jammu and Kashmir became an independent state, and its negotiation about the accession of the state to India assumed the character of an international treaty between two sovereign states. Even assuming that position to be correct, the principles of international law governing treaties will apply to the instrument of accession. International law is explicit that the contracting parties cannot revoke the treaty obligation unilaterally unless it becomes obsolete owing to force majeure, an impossibility of performance, or due to vital change of the circumstances. The accession of the state to the Indian Union was further strengthened when the state of Jammu and Kashmir sent its representatives to the Constituent Assembly of India and accepted the Constitution of India. It thereby became a member state of the Indian Union. The undertaking given by the Prime Minister of India that the matter of accession could be reaffirmed or cancelled or cut by the people of Kashmir if they wish to, can at best only have moral value and has no semblance of any legal character. The accession of the state of Jammu and Kashmir was unconditional. It was not subject to any plebiscite. Q. 38. Discuss the 5 freedoms of the air. To what extent are they observed by powers? Ans. 5 freedoms of the air. At the International Civil Aviation Conference held at Chicago in November 1944, an attempt was made to arrive at an agreement on commercial air traffic rights and the enlargement of the horizon of international civil aviation. The United States, the largest operator of international airlines, advocated very elaborate rights of aircraft undertaking transcontinental and transoceanic aviation, which have come to be known by the name of the 5 freedoms of the air. These are: 1. To fly foreign territory without landing. 2. To land for non-traffic purposes, example, to repair a machine. 3. To disembark in a foreign country traffic originating in the state of the origin of the aircraft. 4. To pick up traffic from the state whose territory is used for landing destined for the state to which the aircraft belongs. 5. To take on traffic from the state whose territory is used for landing for any contracting state, or disembark traffic on that territory coming from any contracting state. Only 19 states appended their signatures to the convention embodying the 5 freedoms of the air. Great Britain and some other states did not agree to the convention unconditionally and instead proposed an international control authority to apportion the world's air traffic equitably between all states. Canada supported by stating that the first 4 freedoms be controlled and regulated by an international body that would allocate frequencies to states with agreed principles. There thus emerged two different groups, one group adhering to the 5 freedoms of the air, i.e., favoring free competition, and the other adhering to the proposal of an international control over the enjoyment of these freedoms. The result was that the Chicago Conference failed to bring about a rapprochement between the competing and conflicting principles of air navigation. The matter was left to the states to enter into bilateral agreement for evolving harmony to the divergent rules. Finally, in 1946 the United States withdrew its name from being a party to the 5 Freedoms Agreement and entered into an understanding with Great Britain by means of the Bermuda Agreement the same year, whereby it was made clear that an international regulation and control of air traffic was still a thing of the future. Q. 39. Writ short notes on A. The continental shelf. B. International servitude. Ans. A. Continental shelf. The International Law Commission has defined a continental shelf as that part of the seabed continuous to the coast, but outside the areas of marginal seas, where the depth of the superjacent waters admitted of the exploitation of natural resources of the seabed and subsoil. The Commission has provided that the coastal states might exercise control and jurisdiction for the purpose of exploiting the natural resources of the shelf, but the legal status of the superjacent waters and of the air space above might not be affected thereby. The main reason for the present mere chaos of the law of the sea seems to be the elastic definition of the outer boundary of the continental shelf given by the relevant Geneva Convention. B. International servitude. Stark defines an international servitude as an exceptional restriction imposed by treaty on the territorial sovereignty of a particular state whereby the territory of that state is put under conditions or restrictions serving the interests of another state. Servitude may either be positive or negative in character. The former means that a state has a right to perform acts on the territory of another state. The latter connotes that the state bound by the servitude must refrain from doing something on that territory or abstain from exercising its territorial rights in some ways. Oppenheim mentions two more kinds of servitudes, viz., military and economic. The former is a servitude acquired for military purposes, such as the right to keep troops in foreign territory. The latter is a servitude which is acquired for the purpose of commercial interests. Q. 40. What do you mean by hijacking? Discuss aircraft hijacking with the case law. Ans. In wider sense, hijacking is an act against the safety of traffic in the air, is comparable to piracy, an act against the safety or traffic on the open sea. Article 1 of the Hague Convention, 1970, contains the concept of hijacking in the following words. Any person who on board an aircraft in flight A. Unlawfully, by force or threat thereof, or by any other form of intimidation, seizes or exercises control of that aircraft, or attempts to perform any such act, or B. Is an accomplice of a person who performs or attempts to perform any such offense. This provision again, instead of defining the term hijacking, simply enumerates the constituent elements of hijacking. The concept of hijacking has been further widened in the Montreal Convention 1971. Article 1 of the Montreal Convention provides 1. Any person commits an offense if he unlawfully and intentionally A. Performs an act of violence against a person on board on aircraft in flight if that act is likely to endanger the safety of that aircraft, or B. Destroys an aircraft in service or causes damage to such an aircraft which renders it incapable of flight or which is likely to endanger its safety in flight, or C. Places or causes to be placed on an aircraft, in service, by any means whatsoever, a device or substance which is likely to destroy that aircraft, or to cause damage to it which renders it incapable of flight, or to cause damage to it which is likely to endanger its safety in flight, or D. communicates information which he knows to be false, thereby endangering the safety of an aircraft in flight. 2. Any person also commits an offense if he a. attempts to commit any of the offenses mentioned in paragraph 1 of this article, or b. is an accomplice of a person who commits or attempts to commit any such offense. Hijacking of an Indian aircraft and the ICO jurisdiction case. On 30th January 1970, two persons hijacked an Indian aircraft to Lahore, Pakistan. Instead of apprehending and punishing them, the government of Pakistan encouraged them. Consequently, the hijackers burned the aircraft at the airport, and this incident was shown to the people of Pakistan through television. Thus, Pakistan flagrantly violated Article 11 of the Tokyo Convention. It was also the violation of the United Nations Security Council Resolution 286, 1970, which called on states to take all possible legal steps to prevent further hijacking or any other interference with international civil air travel. Consequently, India banned all Pakistani flights through her territory. Pakistan filed a complaint in the Council of the ICO against this. On the other hand, India filed an application in the International Court of Justice challenging the jurisdiction of the Council of ICO to hear and decide Pakistani complaint, ICJ Reports 1972, pp. 46 ff. It was argued on behalf of India that India, being a sovereign state, is fully entitled either to allow or not to allow overflights of aircraft of other countries through her territory. But Pakistan challenged the jurisdiction of the World Court to hear and decide India's application. The court, by 13 votes to 3, rejected the government of Pakistan's objections on the question of its competence and held that it had jurisdiction to entertain India's appeal. By a majority of 15 votes to 2, the World Court further held the Council of ICO to be competent to entertain the application and complaint laid before it by the government of Pakistan on 3 March 1971, and in consequence rejected the appeal made to the court by the government of India against the decision of the Council assuming jurisdiction in those respects. It may be noted here that the World Court simply gave its verdict relating to the competence of the Council of ICO. It did not go into the merits of respective claims of the parties relating to the banning of Pakistani overflights and the incidents which led to such ban. Later on, India and Pakistan entered into Simla Agreement and agreed to settle all their disputes through peaceful means and through bilateral negotiations. Subsequently, Delhi Agreement, 1973, and Delhi Tripartite Agreement, 1974, were entered into to resolve matters relating to the repatriation of Pakistani prisoners of war. The representatives of India and Pakistan have also held several rounds of talk relating to the resumption of flights of aircraft by both countries over the territory of each other, but with no success so far. The main stumbling block in the solution of this problem is Pakistan's persistent refusal to withdraw her case pending before the Council of ICAO. India made it clear that she would not entertain any proposal for resumption of Pakistani overflights through her territory unless and until Pakistan first withdraws her case from the Council of ICAO. This stand was in conformity with the letter and spirit of the Simla Agreement between the two countries. Later on, Pakistan withdrew the complaint from the ICAO Council, and India allowed the resumption of overflights through her territory. Q41. What do you understand by the term piracy? What are the essential elements of piracy? Ans. Definition. There has been a great controversy in respect of the definition of the term piracy. Different jurists have given different definitions of the term piracy. In an American case, the Ambrose Light, 25 Fed. Re. 408, the federal court expressed the view that the armed ship in the sea should be under the authority of some state, and if such a ship is not under the authority of any state, it would be treated in the category of pirate ships, irrespective of the fact whether it has committed piracy or not. The law relating to piracy was codified in the Geneva Convention on High Seas, 1958. Article of the Convention defines piracy in the following words. Piracy consists of any of the following acts. 1. Any illegal act of violence, detention or any act of depredation committed for private ends by the crew or the passengers of a private ship or a private aircraft, and directed a. on the high seas, against another ship or aircraft, or against persons or property on board such ship or aircraft. b. against a ship, aircraft, persons or property in a place outside the jurisdiction of any state. 2. Any act of voluntary participation in the operation of a ship or of an aircraft with knowledge of facts making it a pirate ship or aircraft. 3. Any act of inciting or of intentionally facilitating an act described in subparagraph 1 or subparagraph 2 of this article. The definition noted has been retained without any change in Article 101 of the UN Convention on the Law of the Sea, 1982. A ship or aircraft is considered a pirate ship or aircraft if it is intended by the persons in dominant control to be used for the purpose of committing one of the acts referred to in Article 15. The same applies if the ship or aircraft has been used to commit any such act, so long as it remains under the control of the persons guilty of that act. Article 17 of the 1958 Geneva Convention on the High Seas. Essential elements of piracy. Following are the essential elements of piracy. 1. Violence or robbery at high seas must be for private ends. Such acts committed by warships, government ships or aircraft cannot be called piracy. For example, in the Second World War, German U-boats sunk enemy ships in the area of long-distance blockade in the high seas without any prior intimation. This act cannot be called piracy because it was committed under the authority of the state of Germany. In fact, this act is violation of the laws and custom of war and a war crime. 2. Illegal acts of violence, detention, or any act of depredation committed for private ends must be by the crew or passengers of a private ship or a private aircraft. The only exception to this is recognized in Article 16, which provides that the acts of piracy committed by a warship, government ship or government aircraft, whose crew has mutinied and taken control of the ship or aircraft are assimilated to acts committed by a private ship. 3. Illegal acts of violence, detention, or any act of depredation may be either on the high seas or in a place outside the jurisdiction of any state. 4. Such acts must be directed against a ship, aircraft, persons or property. 5. Violence, detention, or any act of depredation may constitute piracy provided that above elements are satisfied. 6. Committing of actual robbery is not essential for piracy. Even an unsuccessful attempt to commit robbery at high seas will constitute piracy. This was held in Re Piracy Jure Gentium, 1934, AC 586. The facts of this case are as follows. In 1931, some Chinese citizens were arrested on the charge of piracy. They were tried in Hong Kong and held guilty. In this case, accused had made an unsuccessful or abortive attempt to commit robbery at high seas. The court was confronted with the question as to whether actual robbery was essential for piracy. The Hong Kong court referred this question to the Privy Council for its opinion. The Privy Council held that an act to constitute piracy, actual robbery, is not essential. Even if an accused is guilty of making an unsuccessful attempt to commit robbery, he will be guilty of having committed piracy and will be punished. 7. Any act of voluntary participation in the operation of a ship or an aircraft with knowledge of facts making it a private ship or aircraft will also constitute piracy. Article 15, 2 of the Geneva Convention on the High Seas. 8. Any act of inciting or of intentionally facilitating any illegal act described above will also constitute piracy. Q. 42. Define. A. Maritime belt or territorial waters. B. Contiguous zone. Ans. A. Maritime belt or territorial waters. The 1958 Geneva Convention on Territorial Waters and Contiguous Zone provided that the coastal state exercises sovereignty over that part of the sea which is called maritime or territorial waters. The coastal state exercises sovereignty not only over the territorial waters, but also over airspace above it. Article 2 of the UN Convention on the Law of the Sea, 1982, contains a similar provision. Problems of width of the territorial waters. Up to 18th century the canon shot rule was prevalent. According to Kashuk, the breadth of the maritime belt extends to that distance where a cannon can fire. Up to 19th century the range of cannon shot was generally 3 miles. In the 19th century, the 3-mile cannon shot rule became very much prevalent. Scientific inventions and discoveries made this rule inadequate because the range of cannon shot increased considerably. According to Grotius, the sovereignty of a coastal state over maritime belt should extend to that area up to which it can exercise effective control. Famous jurist Vassal also subscribed to this view. Few countries of the world still voluntarily subscribe to 3-mile rule, but international law did not fix any width of the territorial waters. In order to fix the width of maritime belt, the first important attempt was made in the Hague Conference of 1930, but with no success. The next important attempt was made in the Geneva Conference on the Law of the Sea, 1958, but no agreement could be reached. Different states claimed different width of territorial waters. The extreme case was that of Chile, Peru, Equator, claiming territorial waters extending to 200 miles. The general consensus was, however, between a territorial waters extending from 3 miles to 12 miles. In order to solve this unresolved problem, another Geneva Conference was held in 1960, wherein the United States of America submitted a compromise formula. This formula envisaged 6 miles of territorial waters, and outside this there should be another 6 miles given to the coastal state for fishing, etc. Unfortunately, this proposal could not be accepted as it was defeated by a majority of a single vote. India claimed territorial waters up to 3 miles up to the year 1956. In that year, India extended its territorial waters of 3 miles to 6 miles through a presidential proclamation, and later on to 12 miles in 1967. The controversy finally ended with the adoption of the UN Convention on the Law of the Sea, 1982. According to Article 3 of the Convention, breadth of territorial sea is 12 nautical miles measured from baseline. B. Contiguous zone. Contiguous zone is that part of the sea which is beyond and adjacent to the territorial sea of the coastal state. According to Article 53 of the UN Convention on the Law of the Sea, 1982, in a zone contiguous to its territorial sea, the coastal state may exercise the control necessary to a. Prevent infringement of its customs, fiscal, immigration or sanitary regulation within its territory or territorial sea. B. Punish infringement of the above regulations committed within its territory or territorial sea. The contiguous zone may not extend beyond 24 miles from which the breadth of territorial sea is measured. That is to say, it is 12 miles beyond the territorial sea. Q. 43. Define. A. Continental shelf. B. Exclusive economic zone, EEZ. ANS. A. Continental shelf. The construction of the oceans and seas is such that as we proceed seaward they become more and more deeper and a place from where sea becomes steepy. Around most continents there is a belt of fairly shallow sea, unusually less than 600 feet, and this depends only as one passes through seaward from coast. The seabed and subsoil of this fringe of shallow sea, which may be several hundred miles wide, is called the continental shelf. The legal concept of continental shelf came into limelight since Truman Proclamation of 1945, wherein it was declared that the United States of America considered the resources of the shelf contiguous to the United States as pertinent to the United States and subject to its jurisdiction and control. It was, however, made clear that this was in no way to affect the character of the high seas above the shelf. Being encouraged by the Truman Proclamation, certain other states such as Mexico, Argentina, and Cuba made similar proclamations. Article 1 of the Geneva Convention on the Continental Shelf, 1958, defined continental shelf in the following words: the continental shelf is a. the seabed and subsoil of the submarine areas adjacent to the coast, but outside the area of territorial sea to depth of 200 meters, or beyond that limit to where the depth of superjacent water admits all exploitation of natural resources of the said areas. B. to the seabed and subsoil of similar submarine areas adjacent to the coast of island. The above definition has been severely criticized. It is said, and rightly too, that it has created more problems than solved them. The definition does not fix any outer limit of the continental shelf. It was, therefore, urgently felt that the definition of the continental shelf contained in the Geneva Convention on the Continental Shelf, 1958, should be revised at an early date. Outer limits of continental shelf. Though the problem of the definition of the continental shelf was satisfactorily solved, the problem of the outer limits of continental shelf still remained. This was due to the problem of precisely defining the outer limit of the continental margin. With a view to avoid any ambiguity in the legal regime of the continental shelf to be established, and to fix precise outer limits of the continental shelf of coastal state, paragraph 4a of Article 76 of the UN Convention on the Law of the Sea, 1982 provides the following. For the purposes of this convention, the coastal state shall establish the outer edge of continental margin wherever the margin extends beyond 200 nautical miles from the baselines from which the breadth of the territorial sea is measured by either I. a line delineated in accordance with paragraph 7 by reference to the outermost fixed points at each of which the thickness of sedimentary rocks is at least 1% of the shortest distance from such point to the foot of the continental slope, or 2. After having provided the above method of establishing the outer edge of the continental margin, the Draft Convention on the Law of the Sea lays down the formula for fixing the precise limits of the continental shelf of a coastal state in paragraph 5 of the Article 76 in following words: the fixed points comprising the line of the outer limits of the continental shelf on the seabed drawn in accordance with paragraph 4a, I, and 2. Either shall not exceed 350 nautical miles from the baselines from which the breadth of the territorial sea is measured, or shall not exceed 100 nautical miles from the 2,500 meters isobath, which is a line connecting the depth of 2,500 meters. B. Exclusive economic zone. After the concept was first advocated by Kenya, it has attracted many adherents. The Third UN Conference on the Law of the Sea deserves credit for having settled the provisions relating to the concept of exclusive economic zone. These provisions now find mention in UN Convention on the Law of the Sea, 1982. Article 55 of the Convention provides that the exclusive economic zone is an area beyond and adjacent to the territorial sea, subject to the specific legal regime established in this Part I Part V, under which the rights and jurisdictions of the coastal state and freedom of other states are governed by the relevant provisions of this convention. Article 56, which deals with rights, jurisdictions, and duties of a coastal state in the exclusive economic zone, provides the following. 1. In the exclusive economic zone, the coastal state has a. Sovereign rights for the purpose of exploring and exploiting, conserving and managing the natural resources, whether living or non-living, of the seabed and subsoil and the superjacent waters, and with regard to other activities for the economic exploitation and exploration of the zone, such as the production of energy from the water currents and winds. B. Jurisdiction as provided for in the relevant provisions of this convention with regard to I. The establishment and use of artificial islands, installation and structures. 2. The protection and preservation of the marine environment. C. Other rights and duties provided for in this convention. 2. In exercising the rights and performing its duties under this convention in the exclusive economic zone, the coastal state shall have due regard to the rights and duties of other states and shall act in a manner compatible with the provisions of this convention. As regards the breadth of the exclusive economic zone, Article 57 provides that it shall not exceed beyond 200 nautical miles from the baseline from which the breadth of the territorial sea is measured. As regards the rights and duties of other states in the exclusive economic zone, Article 58 provides the following. 1. In the exclusive economic zone, all states, whether coastal or landlocked, enjoy, subject to the relevant provisions of this convention, the freedoms referred to in Article 87 of navigation and overflight and of the laying of submarine cables and pipelines and other internationally lawful uses of the sea related to these freedoms, such as those associated with the operation of ships, aircraft and submarine cables and pipelines, and compatible with the other provisions of this convention. 2. Articles 88 to 115. These articles relating to the high seas and other pertinent rules of international law apply to the exclusive economic zone insofar as they are not incompatible with this part. 3. In exercising their rights and performing their duties under this convention in the exclusive economic zone, states shall have due regard to rights and duties of the coastal state and shall comply with the laws and regulations adopted by the coastal state in accordance with the provisions of this convention and other rules of international law insofar as they are not incompatible with this part. It may be noted here that the concept of exclusive economic zone as highlighted by the 1982 Convention on the Law of the Sea has already become part of modern law. Case concerning the continental shelf, Tunisia, Libya, ICJ, Riyadh. 1982, p. Q 44. Define. A. Freedom of high seas. B. International seabed areas. Ans. A. Freedom of the high seas definition. The concept of freedom of open sea or high seas is very old. In the modern time it has assumed an added significance. According to Fenwick, open sea or high sea is the sea outside the territorial waters. Charles C. Jenwick International Law, 3rd Indian reprint, 1971, p. 496. In 1958 a convention was adopted on the high seas which is known as the Geneva Convention on the High Seas, 1958. Article 1 of the said convention provides, the term high seas means the parts of the sea that are not included in the territorial sea or in the internal waters of a state. See UN Doc.A.Conf.13L 53. In view of the recent developments, particularly the emergence of the concept of exclusive economic zone, this definition has become obsolete and inadequate. Article 86 of the UN Convention on the Law of the Sea, 1982, therefore, provides that the provisions of this part, i.e. Part 7, apply to all parts of the sea that are not included in the exclusive economic zone, in the territorial sea or in the internal waters of a state, or in the archipelagic waters of an archipelagic state. This article does not entail any abridgment of the freedoms enjoyed by all states in the exclusive economic zone in accordance with Article 58. Article 2 of the 1958 Geneva Convention on the High Seas provides that the freedom of the high seas comprises inter alia, both for coastal and non-coastal state. 1. Freedom of navigation. 2. Freedom of fishing. 3. Freedom to lay submarine cables and pipelines, and 4. Freedom to fly over the high seas. These freedoms, and others which are recognized by the general principles of international law, shall be exercised by all states with reasonable regard to the interests of other states. This is to say, the freedoms enumerated are not exhaustive. They are in addition to those recognized by the general principles of international law. B. International seabed area. Definition and delimitation of the area. The first essential requirement of a legal regime of the international seabed area, hereinafter called the area, is that the precise limits of the area should be clearly defined and they should be delimited from other maritime zones. The area has been defined as the seabed and ocean floor and subsoil thereof beyond the limits of national jurisdiction. A pertinent question therefore arises as to what is the outer limit of coastal states' jurisdiction in seabed. The first and second UN conferences on the law of the sea failed to solve this question satisfactorily. The first UN Conference on the Law of the Sea, which was held in Geneva in 1958 and which adopted 4 conventions including the Convention on the Continental Shelf, failed miserably to fix the outer limits of continental shelf. It need not be overemphasized here that the outer limit of continental shelf is the limit where the coastal state's national jurisdiction in seabed ends. Beyond the continental shelf, the sea bottom falls away more steeply into deep water, until it levels out again in the floor of main ocean basins, which lie as much as 10 or even 15,000 feet below the surface. The area may therefore be defined as the seabed and ocean floor of the sea and subsoil thereof beyond the continental shelf of a coastal state and extending up to the continental shelf ends. Q. 45. Enlist the important provisions of Outer Space Treaty. Ans. The Outer Space Treaty. Some of the important provisions of the Outer Space Treaty of 1966 are as follows. 1. Outer space, including the moon and other celestial bodies, shall be free for exploration and use by all states without discrimination of any kind, on a basis of equality, and in accordance with law. There shall be free access to all areas of celestial bodies. There shall be freedom of scientific investigation in outer space. Article I of Outer Space Treaty of 1966. 2. Outer space, including the moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty, by means of use or occupation, or by any other means. Article 2. Therefore, if a state X lands craft on the moon and claims to have acquired an inchoate title to territory, the claim will be invalid. If the state concerned is the party to the Outer Space Treaty, the claim will be invalid by virtue of Article 11 noted above. The answer will be same even if the state concerned is not a party to the treaty because of General Assembly Resolution 1962-18, entitled Declaration of Legal Principles Governing the Activities of States in the Exploration and Use of Outer Space, which was adopted unanimously by the United Nations General Assembly on December 1963. 3. State parties to the treaty undertake not to place on orbit around the Earth any objects carrying nuclear weapons or any other kind of weapons of mass destruction, install such weapons on celestial bodies, or station such wearers in outer space in any other manner. 11. Article 4. See also General Assembly Resolution 1884-17, dated 17th October 1963. 4. The moon and other celestial bodies shall be used by all states parties in treaty exclusively for peaceful purposes. The establishment of military bases, installations and fortifications, the testing of any type of weapons, and the conduct of military maneuvers on celestial bodies shall be forbidden. Article 4. 5. State parties to the treaty shall regard astronauts as envoys of mankind in outer space and shall render to them all possible assistance in the event of accident, distress or emergency landing on the territory of another state party or on the high seas. When astronauts make such a landing, they shall be safely and promptly returned to the state of registry of their space vehicle. Article V. 6. State parties to the treaty shall bear international responsibility for national activities in outer space. Article 6. Q. 46. What problems of international law arise in the man's conquest of Moon and Mars? Discuss with reasons. Ans. Conquest of Moon and Mars. According to Oppenheim, occupation is the act of appropriation by a state through which it intentionally acquires sovereignty over such territory as is at the time not under the sovereignty of another state. It, therefore, relates to the establishment of sovereignty over a territory which had either been unoccupied or had recently been discovered. It is a means of acquiring territory not already in the dominion of any state. In order to constitute occupation, there must be the intention or will of a state to take possession of unappropriated territory and settlement upon the land, i.e., establishment of some form of control over the occupied area. Oppenheim calls possession and administration as the two essential facts that constitute an effective occupation. By possession he means that the occupying state must take the territory under its sway, corpus, with the intention of acquiring sovereignty over it, animus. This is done by settlement on the territory, accompanied by some formal act which announces both that the territory has been taken possession of and that the possessor intends to keep it under his sovereignty. By administration, Oppenheim means that the possessor must establish some kind of administration on the territory which shows that the territory is really governed by the new possessor. Now, in the instant case, there cannot be any territorial claim on the Moon arising from the landing of cosmic rocket on the Moon's surface. Even the planting of flags on the Moon or any other heavenly body is not enough to claim sovereignty over it. The assertion of sovereignty must be displayed. It should be actual and not merely a nominal one on a paper claim. The claimant must act in a way which is legitimate of an international sovereign to act in order to exercise sovereignty. Nothing is to happen by man's conquest of Moon and Mars. Mere discovery of a land or conquest of Moon does not constitute acquisition through occupation. It gives an inchoate title, which is incapable of perfection by effective control and administration, i.e., by means of settlement, as an act of possession, since the inchoate title cannot be perfected into a real title of occupation within a reasonably sufficient time. The inchoate title will wither away and no problem of international law is to arise in the foreseeable future. Article I of the Treaty of Principles Governing Activities of State in the Exploration and Use of Outer Space, including the Moon and other celestial bodies, signed at Washington, London and Moscow on 27 January 1967, specifically lays down that the exploration and use of outer space, including the Moon and other celestial bodies, shall be carried out for the benefit and in the interests of all countries irrespective of their degree of economic or scientific development and shall be the province of all mankind. Outer space, including the Moon and the other celestial bodies, shall be free for exploration and use by all states without discrimination of any kind, on a basis of equality and in accordance with international law, and there shall be free access to all areas of celestial bodies. Article 2 lays down that outer space, including the moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty, by means of use or occupation, or by any other means. Article 4 provides that the moon and other celestial bodies shall be used by all states parties to the treaty exclusively for peaceful purposes. The establishment of military bases, installations and fortifications, the testing of any type of bodies shall be forbidden. After tough negotiations lasting 7 years, the 47-nation United Nations Outer Space Committee reached agreement in July 1979 on a draft treaty on the Moon, proclaiming that its unexplored natural resources shall be the common heritage of mankind and that the Moon is not subject to national appropriation by any claim of sovereignty, by means of use or occupation, or by any other means. The draft treaty was then sent to the General Assembly for adoption. Q. 47. Write a short note on the peaceful uses of the seabed and outer space. Ans. Peaceful uses of seabed. In June 1968, the General Assembly set up a standing committee on the peaceful uses of the seabed and the ocean floor beyond the limits of national jurisdiction. It functions largely through two subsidiary bodies, a legal subcommittee which studies the legal principles to promote international cooperation and to ensure exploitation of the resources of the seabed and ocean floor for the benefit of mankind, and a scientific and technical subcommittee which deals with these specified aspects. In 1960, the General Assembly declared that, pending the establishment of an international regime, states and persons should refrain from all exploitation of the resources of the seabed and ocean floor beyond national jurisdiction, and no claim on the part of the sea or its resources shall be recognized. On 17 December 1970, the General Assembly of the United Nations, while planning for a third United Nations Conference on the Law of the Sea, adopted a Declaration of Principles, which inter alia laid down that the seabed beyond that limits of national jurisdiction and its resources shall constitute a common heritage of mankind, i.e., a space not subject to appropriation by individual states or persons, and to be exclusively used for peaceful purposes for the benefit of mankind as a whole. To be administered and exploited by the international community as such. Peaceful uses of outer space. The Treaty on the Peaceful Uses of Outer Space, commended to the states by the General Assembly and containing principles to be observed in the exploration and use of outer space, was signed on 27 January 1967 and came into force on 10 October 1967. The accretion of this treaty to the law of nations has forged a permanent disarmament agreement for outer space. This treaty on principles governing the activities of states in the exploration and use of outer space, including the moon and other celestial bodies, provides that there shall be freedom of scientific investigation in outer space, including the moon and other celestial bodies, and the states facilitate and encourage international cooperation in such investigation, and that outer space, including the moon and other celestial bodies, was not subject to national appropriation by claim of sovereignty by means of use or occupation, or by any other means. Further, the moon and other celestial bodies shall be used by all states parties to the treaty exclusively for peaceful purposes and the establishment of military bases, installations and fortifications, the testing of any type of weapons and conduct of military maneuvers on celestial bodies shall be forbidden. In order to promote international cooperation in the peaceful exploration and use of outer space, states parties to the treaty conducting activities in outer space including the moon and other celestial bodies have agreed to inform the Secretary General of the United Nations of the nature, conduct, locations and results of such activities to enable him to disseminate it immediately effectively. Besides the treaty, there is an agreement which came into effect on 3rd December 1968 on the rescue and return of astronauts and the return of objects launched into outer space, under which parties agree to procedures for aiding the crews of spacecraft in the event of accident or emergency landing. On 27 January 1971, the Academy of Science of the USSR and the U.S. National Aeronautics and Space Administration signed an agreement for better cooperation in space efforts. It aims at exchange of information and joint endeavors in the fields of meteorology, environment, space biology, and medicine and space exploration. The Convention on International Liability for Damage Caused by Space Objects, as adopted by the General Assembly on 29 November 1971, provides that a state or states launching or jointly launching a space object shall be absolutely or jointly and severally liable to pay compensation for damage caused by its space object on the surface of the earth or to aircraft in night. Q. 48. Define nationality. What are the various modes of acquiring and losing of nationality? Ans. Nationality is the status of natural person who is attached to a state by the tie of allegiance. Harvard Draft Convention on Nationality, 1929, AJIL, Special Supplement, p. 13. In the words of Hyde, nationality refers to the relationship between a state and an individual which is such that the former may with reason regard the latter as owing allegiance to itself. Hyde, International Law, Volume 2, p. 1064. Acquisition of nationality. Following are the modes of acquisition of nationality. 1. By birth. A person acquires nationality of the state where he is born. He also acquires the nationality of his parents at the time of his birth. 2. By naturalization. Nationality may also be acquired by naturalization. When a person living in foreign state acquires the citizenship of that state, then it is said to be acquired nationality through naturalization. 3. By resumption. Sometimes a person may lose his nationality because of certain reasons. Subsequently, he may resume his nationality after fulfilling certain conditions. 4. By subjugation. When a state is defeated or conquered, then all the citizens acquire the nationality of the conquering state. 5. Cession. When a state has been ceded in another state, then the people of the territory which has been ceded acquire the nationality of the state in which their territory has been merged. In addition to the above-mentioned modes, there may be some other circumstances whereby a person may acquire nationality. For example, if a person is appointed in the public service of another state, then acquires the nationality of that state. Loss of nationality. Following are the modes of loss of nationality. 1. By release. In some states, law provides that the citizens may lose the nationality by release. In the loss of nationality by release, it is necessary to submit an application for the same. If the application is accepted, the person concerned is released from the nationality of the state concerned. 2. By deprivation. In certain states, law provides that if the national of that state without seeking prior permission of the government obtain employment in another state, then he may be deprived of his nationality. 3. Long residence abroad. Yet another mode of loss of nationality is the long residence abroad. The state laws of many states contain provisions in this connection. Thus, if a person resides for a long period abroad, then his nationality ends. 4. By renunciation. A person may also renounce his nationality. The need for renunciation arises when a person acquires nationality of more than one state. In such a condition, he has to make a choice as to of which country he will remain the national. Consequently, he has to renounce the nationality of one state. 5. Substitution. Some states provide for the substitution of nationality. According to this principle, a person may get nationality of a state in place of the nationality of another state. This is called nationality by substitution, whereby he loses the nationality of one state and acquires the nationality of another state. Q. 49. Differentiate between A. Nationality and domicile. B. Nationality and citizen. Ans. A. Distinction between nationality and domicile. It has been pointed out earlier that basis of nationality is the membership of a man with an independent community. On the other hand, domicile denotes the residence of the person. Thus, there is a great difference between nationality and domicile. While nationality denotes the relation of a man with his nation which protects him, and the person is bound to follow the rules enacted by that state, on the other hand, domicile denotes the residence of the person. Consequently, a person may acquire nationality through domicile. In different countries, there are different rules and processes in regard to the acquisition of nationality through domicile. In Boldrini, 1932, Probate 9, 15, it was held that a man may change his domicile without losing or changing his nationality. Conversely, it has been held in Valby, AG, 1932, 147 LT 382, that a man may change his nationality without a change of his domicile. The Indian courts have also applied these principles. Attaula v. Attaula, AIR 1953 calories. 530, and Michael Anthony Rodriguez v. State of Bombay, AIR 1956 bomb. 729 deserve mention in this connection. The point that a person acquired British nationality would not imply that he had acquired the domicile of UK too. This was held by the Calcutta High Court in SP Ghose v. Deputy Comptroller, Reserve Bank of India, AIR 1964 calories. 422. It has been aptly remarked, though the two concepts are quite independent of each other, but sometimes, domicile is made one of the important criterion for the acquisition of the nationality or citizenship of a country. S.K. Agrawal, International Law, Indian Courts and Legislature, 1965, p. 113. B. Distinction between nationality and citizenship. Often nationality and citizenship are considered to be synonymous of each other. But the fact is otherwise. There is a great difference between nationality and citizenship. By nationality under international law, we mean the legal relationship which exists between the nation and the state. Citizenship, on the other hand, denotes the relation between the person and the state law. In other words, we may say, rights of a person may come under international law, whereas the rights of citizenship are the sole concern of the state law. It is possible that all the citizens possess the nationality of a particular state, but it is not necessary that all the nationals may be the citizens of that particular state. Citizens are those persons who possess all political rights in that state. But a person who possesses only nationality in a particular state may possess all political rights. Thus, there is a great difference between nationality and citizenship. The distinction between nationality and citizenship has been aptly summed up in the following words, Ibid. at pp. 96-97. It is nationality only which is of significance to international law and not citizenship. Citizens are included in nationals, but not all nationals are citizens. It may be noted here that the Indian Citizenship Act, 1955 does not make any distinction between the words nationality and citizenship. Q. 50. Define double nationality and the nationality of a married woman. Ans. Double nationality and nationality of married woman. Because of the conflict of the laws of nationality of different countries, a situation often arises when a person may possess nationality of more than one state. To give example of such a case is that of a woman who after her marriage acquires the nationality of her husband and also continues to possess her original nationality. The double nationality may also be acquired by birth if the parents are at the time of birth in a state whose nationality they do not possess. Consequently, treaties may provide that the persons may, by their will, select their nationality. The Hague Conference of 1930 made an attempt to remove the difficulty arising out of double nationality in consequence of war. Articles 3 to 6 of the Hague Convention contain the provisions in this connection. For example, Article 5 provides that such a person shall be treated in their state as if he has only one nationality. The third state will either recognize the nationality of the state where he often resides, or will recognize the nationality which is more relevant in accordance with the facts and circumstances of each individual case. Articles 8 to 11 provide for the nationality of married women. In these provisions, an endeavor has been made to remove the difficulties. According to the principles contained in these provisions, if a woman marries, then she will automatically acquire the nationality of her husband. In the recent times, the Convention on the Nationality of Married Women is yet another significant attempt to remove the difficulties and problems arising out of the double nationality. Q51. Write a short note on statelessness. Ans. Statelessness. Sometimes it so happens that a person does not possess the nationality of any state. Such a state is referred to as the state of statelessness. In Stoic v. The Public Trustee, 1921, to ch. 67, it was held that it is generally agreed that if a person is not a national of any state, he will be called a stateless person. Lord Russell observed that such a status is recognized by British law as well as international law. At present, this is one of the burning problems of international law. The person who does not possess the nationality of any nation cannot exercise the rights conferred upon him by international law. Professor Oppenheim has compared such persons with the ships who are floating in the open sea, without flag of any country. Serious attempt to remove the difficulties arising out of statelessness was made in the Hague Convention of 1930. Later on, after the establishment of United Nations, attention was given to remove the difficulties arising out of this problem. According to Article 15 of the Universal Declaration of Human Rights, each person is entitled to have nationality, and the nationality of any person cannot be taken away or snatched arbitrarily. The Universal Declaration of Human Rights inspires the state to regulate their conduct in accordance with the provisions of the Declaration so far as the problem of statelessness is concerned. Q52. What do you understand by extradition? Give in short the law relating to extradition and refer to leading cases. What are the necessary conditions for extradition? Ans. Extradition. Where a person who has committed an offense in one country escapes to another, what is the duty of the latter with regard to him? Should the country of refuge try him in its own courts, according to its own laws, or deliver him up to the country whose law he has broken? To the general question, international law gives no certain answer. The universal practice of nations, however, is to surrender fugitive offenders only in consequence of some special treaty with the country which demands them, and few jurists now affirm any general duty or perfect obligation. This surrender in accordance with treaty and in compliance with formal demand is known as extradition. Lawrence defines extradition as the surrender by one state to another of an individual who is found within the territory of the former, and is accused of having committed a crime within the territory of the latter, or who having committed a crime outside the territory of the latter, is one of its subjects and, as such, by the law amenable to its jurisdiction. Difficulties. There are two practical difficulties about extradition, which have prevented the growth of a uniform rule on the subject. They are the variations in the definitions of crime adopted by different countries and the possibility of the process of extradition being employed to get hold of a person who is wanted by his country not really for an ordinary crime, but for a political offense. Modern states almost invariably exclude offenses of a political character from the operation of the law of extradition. It is now generally agreed that surrender is a matter of community and not right. Each state is guided by treaty stipulations, and, in their absence, it has a right to refuse to surrender fugitives by granting them asylum in view of the territorial sovereignty. Necessary conditions. The necessary conditions for extradition generally inserted in extradition treaties are as follows. 1. A fugitive criminal shall not be surrendered if the offense in respect of which his surrender is demanded is one of a political character. The term political offense is not easy to define. If has, however, been established according to judicial decisions that to constitute a political offense there must be two or more parties, each seeking to impose government of its own choice on the other or striving for political control in the state where the offense is committed, and the offense must be in pursuance of that objective. 2. Military offenses, example, desertion, and religious offenses are also generally not subject to extradition proceedings. The rule is that extradition is not allowed for trifling cases. 3. The fugitive demanded shall not be liable to be tried for any offense committed prior to his surrender other than the specified offense mentioned in the request for his extradition until he has been liberated and has had an opportunity of leaving the country. In the case of United States v. Rocher, 1886, Rocher, a sailor, was surrendered by Great Britain to USA upon a charge of murder. He was, however, tried and convicted in USA upon a minor charge of inflicting cruel and unusual punishment to the man of whose murder he was accused before. On appeal, the Supreme Court of the United States quashed the conviction and ordered the release of the prisoner on the ground that, unless otherwise provided for by treaty, the prisoner could only be charged with the offense for which he was extradited unless he was given a reasonable time to return to the country which surrendered him. 4. The crime must be an offense in both the states. This is based on the principle of double criminality. Eiler's case. 5. A fugitive criminal who has been accused of some offense being the offense for which his surrender is asked, shall not be surrendered until after he has been tried and has served his sentence for the offense committed in the state requested to surrender. 6. There must be reasonable prima facie evidence of the guilt of the accused. The requested state shall satisfy itself that the evidence submitted justifies prima facie judicial proceedings against the accused, but it is not within the province of the courts of such a state to try the case on its merits. Case laws. 1. Savarkar's case. Savarkar, an Indian and a British subject, was being transported in the P.N.O. boat Moria to India for the purpose of his trial on a charge of high treason and abetment of murder. He escaped to the shore on 25 October 1910, while the vessel was in the harbour of Marseilles. He was, however, seized by a French policeman, who in mistaken execution of his duty, handed him over to the captain without any extradition proceedings. France demanded that Great Britain should give him up and ask his extradition in a formal way in conformity with international law. Great Britain did not comply with this demand. By consent, the matter was referred to the Permanent Court of Arbitration at The Hague. The award, while admitting that an irregularity had been committed by the handing over of Savarkar to the British authorities, decided in favor of Great Britain, holding that there was no rule of international law imposing in such circumstances any obligation on the power which has in its custody a prisoner to restore him because of a mistake committed by the foreign agent who delivered him up to that power. 2. Godfrey's case. In Rakes v. Godfrey, the term fugitive came in for interpretation, and it was observed by Lord Hivort, C.J., that although at the first blush it might appear that when a man is spoken of as a fugitive, what is meant is that he has fled from one country to another country, it seems that the words fugitive criminal are equally satisfied whether the man has physically been present in that country or not, if he committed the crime there. 3. Mubarak Ali's case. In re-Government of India and Mubarak Ali Ahmad, the Queen's Bench referred with approval to Recastuni, in which the court refused extradition because the crime of the fugitive was considered to be political. The present case, however, concerned a man charged with forgery, and even if the case had some political implications into which the court could not inquire, there was no reason to suppose that he would not receive a fair trial, and it would be an impossible position for this court to take up, and an insult to the courts of India to say that he would not. 4. Eiler's case. In the Eiler extradition case, 1949, Gerhard Eiler, an alien communist, convicted in America of some criminal offenses, fled from New York to Poland. He was arrested by the British police officers and produced for trial before a Bow Street magistrate. The British magistrate discharged Eiler from custody on the ground that the offense for which Eiler had been convicted in America, viz., perjury, did not fall under the technical head of perjury in England. This emphasizes the principle of double criminality, i.e., the crime must be an offense in both the states. 5. Dr. Ram Babu Saxena v. The State. Dr. Ram Babu Saxena, member of the UP Executive Civil Service, was appointed in 1948 as administrator, Tonk State, which was then an Indian state and had extradition treaty with the British government. It was alleged that while serving in Tonk State we had committed crimes of extortion and cheating. Dr. Saxena contended that both these offences being not included in the extradition treaty, he was not liable for extradition. Their lordships of the Supreme Court observed that extradition of an Indian subject under S. 7 for an offence which is not extraditable under the extradition treaty entered into between the British government and the Tonk State in 1869 is not, in any sense, a derogation from the provisions of the treaty which provides for the extradition of offenders for certain specified offences, assuming that the Treaty of 1869 still subsisted after the accession of the Tonk State to the Dominion of India. The learned judges were accordingly of opinion that the arrest and surrender of the appellant under S. 7 of the Act was not rendered unlawful by anything contained in the Treaty of 1869, assuming that it still subsisted. 6. Sucha Singh's case. After having murdered the Punjab Chief Minister Pratap Singh Kairo in 1965, Sucha Singh absconded to Nepal. In view of the extradition treaty between India and Nepal, on the request of the Government of India, the Government of Nepal extradited Sucha Singh after initiating proceedings against him in accordance with due law of Nepal. Nepal did not regard the crime as political. Q. 53. Define asylum. Discuss various types of asylum. Differentiate between territorial asylum and diplomatic asylum. Ans. Meaning and definition. By the term asylum we generally mean the shelter and active protection which is extended to a political refugee from another state by a state which admits him on his request. As pointed out by Stark, asylum involves two elements. 1. A shelter which is more than a temporary refuge, and 2. A degree of active protection on the part of the authorities which have control over the territory of asylum. Right to asylum. According to Article 14 of the Universal Declaration of Human Rights, everyone has a right to seek and enjoy in other countries asylum from persecution. It may, however, be noted that the Declaration simply recognizes the right of asylum. It does not grant right to receive asylum. Thus, although everyone has a right to seek asylum, yet there is no corresponding duty of states to grant asylum. Types of asylum and the distinction between them. Asylum may be classified into two categories, I. Territorial asylum and 2. Extraterritorial asylum. Territorial asylum. Territorial asylum is granted by a state in its own territory and is considered as an attribute of territorial sovereignty of the state which grants asylum. On 28 March 1945, a convention on territorial asylum was adopted at Caracas. Article 1 of the said convention runs as follows. Every state has the right in exercise of its sovereignty to admit into its territory such persons it deems advisable. This right has also been recognized in the draft Declaration on Asylum adopted by the United Nations Human Rights Commission. Article 3 of the Declaration provides, "No one seeking or enjoying asylum in accordance with the Universal Declaration of Human Rights should, except for overriding reasons of the population, be subjected to measures such as rejection at the frontier, return or expulsion, which would result in compelling him to return to or to remain in a territory if there is a well-founded fear of prosecution endangering his life, physical integrity or liberty in that territory." The above principle has also been incorporated in Articles 31, 32 and 33 of Refugee Convention of 1951. Example of Dalai Lama and his Tibetan followers. The grant of asylum to Dalai Lama and his followers was an indication of the exercise of territorial sovereignty by India. India as a sovereign state was within her rights to grant asylum to Dalai Lama and his followers in the territory of India. Example of influx of refugees from Bangladesh. As pointed out earlier, each sovereign state can admit or grant asylum to any individual within its territory. India was within her right to grant asylum to millions of refugees from East Pakistan, now Bangladesh, who fled from their native land due to repressive policies followed by and ruthless persecution caused by the military regime of General Yahya Khan. Extraterritorial or diplomatic asylum. A state may also grant asylum in its embassy in foreign countries or in its public vessels. Extraterritorial or diplomatic asylum may be classified into following categories. A. Asylum in foreign legation or diplomatic embassies. Since granting of diplomatic asylum involves a derogation from the sovereignty of the state, international law ordinarily does not recognize a general right of a head of mission to grant asylum in the premises of legation. In order to grant diplomatic asylum, it is necessary to establish its legal basis in each particular case, because of the obvious reason that such a decision leads to the withdrawal of the offender from the jurisdiction of the territorial state and constitutes an intervention in matters which are exclusively within the competence of that state. This was held by the International Court of Justice in the case of the asylum, Colombia v. Peru, ICJ reports, 1950, p. 66. A leading case on asylum in foreign legations is High de la Torre case, ICJ reports, 1951, p. 71. The facts of this case, High de la Torre, a Peruvian citizen, was charged with rebellion. Colombia granted him asylum in her embassy in Peru. After granting asylum, Ambassador of Colombia requested Peruvian government to provide facility to enable Colombia to take High de la Torre outside Peru. This request was made on the basis of Bolivian Agreement, 1911 and Pan American Havana Convention on Asylum, 1928. Colombia contended that asylum was granted because High de la Torre was accused of a political crime. Peru did not agree with this contention and rejected this request. The matter was referred to the International Court of Justice. The court held that Colombia, as the state granting asylum, is not competent to qualify the offense as political by a unilateral and definitive decision binding on Peru. However, the court held that Peru had failed to prove that High de la Torre was accused of an ordinary crime and not a political crime. The court added that asylum to High de la Torre had been irregularly granted because 3 months had passed after the suppression of the military rebellion, which clearly showed that the urgency prescribed by Havana Convention as a condition for the granting of asylum had ceased to exist. But since High de la Torre was a political offender, the court held that despite the fact that asylum had been irregularly granted, Colombia was not bound to surrender High de la Torre. The International Court of Justice held, to infer an obligation to surrender a person to whom asylum has been irregularly granted would be to disregard both the rule of the extra-legal factors involved in the development of asylum in Latin America and the spirit of Havana Convention. B. Asylum in consular premises. The above principles also apply in case of the grant of asylum in consular premises. C. Asylum in the premises of international institution. Generally speaking, international law does not recognize any rule regarding the grant of asylum in the premises of international institution. However, temporary asylum may be granted in case of danger of imminent violence. D. Asylum in warships. There is a controversy in regard to the grant of asylum in warships. Some writers are of the view that asylum can be granted in warships in the territorial waters of a coastal state. On the other hand, some writers have expressed the view that such fugitives should be immediately handed over to the local police, but it is conceded that asylum may be granted to political offenders. E. Asylum in merchant vessels. Since merchant vessels do not enjoy immunity from local jurisdiction, they are not competent to grant asylum to local offenders. Distinction between territorial and extraterritorial asylum. The distinction between territory and extraterritorial asylum has been aptly explained by the International Court of Justice in the asylum case, Colombia v. Peru, ICJ Reports, 1950, p. 266. In the case of extradition, territorial asylum, the refugee is within the territory of the state of refuge. A decision with regard to extradition implies only the normal exercise of territorial sovereignty, the refugee outside the territory of the state where the offense was committed. A decision to grant asylum in no way derogates from the sovereignty of that state. In the case of diplomatic asylum, the refugee is within the territory of the state where offense was committed. A decision to grant diplomatic asylum involves a derogation from the sovereignty of that state. It withdraws offenders from the jurisdiction of the territorial state and constitutes an intervention in matters which are exclusively within the competence of that state. Such a derogation from territorial sovereignty cannot be recognized unless its legal basis is established in such particular case. To sum up, in case of territorial asylum, international law allows a state to grant asylum in exercise of its territorial sovereignty. It may or it may not be treated as a friendly act, but there can be no legal objection to the grant of asylum by a state within its territory. In case of diplomatic asylum, the position is entirely different. Since the offender is within the territory of the state where asylum is to be granted, it is obviously a derogation of the sovereignty of that state and, therefore, in such a case asylum may be granted only in exceptional cases and it is necessary to establish its legal basis in each particular case. Q54. Asylum and extradition are mutually exclusive or asylum stops, as it were, where extradition begins. Comment. Ans. Asylum and extradition are mutually exclusive or asylum stops, as it were, where extradition begins. As noted earlier, asylum is a protection which a state grants in its territory or in some other place under control of certain of its organs to a person who comes to seek it. On the other hand, extradition is the surrender or delivery of the fugitive criminal to the state on whose territory the alleged criminal happens to be. The institution of asylum confers right upon the state to bring the person concerned within its jurisdiction. In case of territorial asylum, the person is in the territory of the territorial state and hence under its jurisdiction. By granting asylum, it grants protection to the person concerned in its territory. In case of diplomatic asylum, the person is not under the jurisdiction of the state granting asylum. Protection is granted to the person concerned and he is brought under the jurisdiction of the granting state. It, therefore, involves derogation from the sovereignty of the territorial state, for through the institution of the asylum the person concerned is withdrawn from the jurisdiction of the territorial state. In both types of asylum, however, the ultimate purpose is to accord protection to the refugee or person concerned and to bring him under the jurisdiction of the granting state. The institution of extradition does just the reverse. In case of extradition, the fugitive criminal is in the territory and under the jurisdiction of the territorial state, and either under an extradition treaty or arrangement or otherwise, it surrenders or returns the fugitive criminal to the state where he is alleged to have committed the crime. Thus the fugitive criminal who is under the jurisdiction of the territorial state is transferred to the jurisdiction of the state where he is alleged to have committed the crime. Thus asylum and extradition are mutually exclusive. Once the territorial state decides to extradite the fugitive criminal, the question of asylum does not at all arise, that is to say, asylum stops where extradition begins. On the other hand, once the state concerned decides to grant asylum to a person, the question of his extradition, at least for the time being, does not at all arise. But after a state has granted asylum to refugee or fugitive criminal, it may subsequently decide to extradite him at the request of the state where he is alleged to have committed the crime or to which state he belongs. Q55. What are the amicable means of settlement of international disputes? Ans. The method of the settlement of international disputes may be divided into two main categories. 1. Pacific means of settlement, and 2. 2. Compulsive or forcible means of settlement.